Yes.
Yes.
Lordship submission item number 21, 22, and 23.
Yes.
My lord, here, my lord, I was praying for 15 days time to file my affidavit and reply. And if
Okay.
the matter can be taken up after that for disposal, my lord, the disciplinary proceeding is on hold. So there's an urgency on the part of the respondents. I had a discussion. I just need to file my reply, my lord.
My lord, may kindly fix a date because Lordship, some urgency is there on our part, Lordship.
It was an expired disciplinary proceeding where final orders have been directed not to be passed in the disciplinary proceedings.
What says represented? The prayer made by Mr. Mazumdar, counsel for the petitioner.
My lord.
Matter stands adjourned to enable him to file affidavit and reply in the matter. Next, my list on. Give a date after 2 weeks.
RT15. RT15.
And the interim orders will continue. my lord.
Okay. Interim order passed release and extended till the next date of listing.
My
Obliged,
obliged.
I have cleared with respect to I don't have 36 laws. Lordship, in this case, I have to file my affidavit, Lordship. Lordship, let it be after 2 weeks, Lordship.
You have
The
informed
other
the
side
other
is there, Lordship.
Okay. What says represented?
36.
3 weeks.
3.
List after,
Interim is there.
list after 3 weeks was to enable the respondents to file the affidavit in opposition in the matter. Interim order passed release stands extended till the next date of listing.
Obliged, Lordship. Highly obliged.
May it please your lordship, I beg to mention item 26 to 30, lordship. It's a batch matter. Consent has been taken. We just need another 2 weeks to file our affidavit, lordship.
You have taken a lot of time, but
Last opportunity, lordship.
okay, both sides are represented. On the prayer made by the learned standing counsel for the PHE.
Lordship.
One last opportunity is granted to file affidavit in opposition to the matter. List on. Give a date after 3 weeks.
Fifth of June.
Obliged.
Yes.
Your lordship, item number 51. Kindly upgrade, lordship. We taken about 2 lordship. SRS Sudhuri advocate, yes, lordship. Taken about 2 lordship. Review petition. 51.
51.
Lordship.
Okay.
2 lordship.
You inform the other side. Inform the NF Railway Council.
Lordship.
May it please your lordship. With consent from the other party, I beg to mention item number 15.
Item
15. For
1-5.
Yes, lordship.
Okay. You are for the petitioner.
Respondent, lordship.
Consent of the other side. Miss,
Next week, lordship.
your name?
Emerson.
Appearing on behalf of standing counsel for Corporation Department, place for adjournment, prayer is allowed. List after?
Next week, lordship.
List in
17.
list in the next week. There any interim order operating?
Check.
Any interim order is there?
No, lordship.
Yes.
Like-
May I please, Lord. My lord, I wish to mention item number 53 of today's list.
Item
53.
53.
My lord, today, my lord, my senior is having some difficulties, my lord. Matter may be taken up after 1 week, my lord.
Okay. List after a week as paid for by Mr. UK Das, counsel for the petitioner. You will inform the other side.
My lord,
Okay.
in front of.
May please your lordship. Lordship, item number 56 from supplementary list. As per the instruction of the petitioner, I would like to withdraw the case with the liberty to file a fresh.
6.
56.
Okay. Also is represented. Upon instructions, Mr. T. Begum,
T. Begum.
learned counsel for the petitioner. 6 to withdraw this writ petition. Here is allowed, barrister is dismissed on withdrawal.
As like.
Any interim order is there?
No, Lordship.
May I please, Lordship, I beg to mention item number 37, Lordship. Kindly pass over the for the day, Lordship. My senior is out of station. 37.
So, okay. Okay. Also, is represented on the prayer made by counsel for the petitioner. Arrestants adjourned today, list in the next week.
Right, Lordship.
Lordship, I beg to mention item number 11, Lordship. With consent of the other side, Lordship, matter will be kindly pass over for the day, Lordship. Any date for next week, Lordship.
Okay, 11, pass over for the day as paid for by and counsel for the petitioner.
Lordship, I beg to mention item number 16,
1-6.
I am on behalf of A Islam, Lordship. Is the out of station, Lordship. Kindly adjourn for 2 days.
On behalf of?
A Islam.
Acha, okay. Okay, also is represented on the prayer made by counsel for the petitioner.
Next
List.
week, next week.
List in the next week.
Yes. Public.
Daily list item 1 for motion.
Actually, Lordship, in this case, when to file the reply of this affidavit, they have filed a Lordship.
Just one.
1 of 10 may be given, Lordship.
Just one. You want to file a reply?
Yes, Your Lordship.
Let me issue a notice because in
Fine,
motion stage it
Then
can
wait
be.
a minute.
Your name?
Yes, Roy, Your Lordship. Yes, Roy.
Mr. S. Roy, counsel for the petitioner. As well as Mr. T.J. Mantal and its senior counsel,
Respond number 2.
assisted by Mr. A. Barwal and counsel, standing counsel for respond number 2. Issue notice returnable in you will be representing LR? One. I think in this case, you will have to also file an affidavit. In this case, you will also have to file an affidavit. Returnable in 4 weeks. Requisite extra copies of the declaration be served on the learned. Mr. A. Chakravarti and government advocate accepting notice on behalf of respondent number 1. Stop. The learned senior counsel for the respondent number 2 has submitted that an affidavit in opposition has already been filed, which is available on record. List after 4 weeks.
Your Lordship,
In
date
the
may-
meanwhile, liberty is granted to the petitioner to file affidavit in reply in the matter.
Your Lordship, date may fix, Your Lordship.
This is an appointment of notary. It's not that urgent. You make a mention if it is not listed.
Item 2.
May I please, Your Lordship? This matter is relating to suspension from service of the petitioner lordship on the strength of his arrest. My lord, the petitioner was suspended with effect from 7/11/2023. Basically, we have challenged the order that is page 26.
No, once you see, once you are arrested,
My lord.
you are not required to pass any speaking order. Why your suspension is extended?
My lord, so far the division bench of this honorable court is concerned, lordship, reason order must be passed, right?
Even after arrest?
Yes.
In ACP case?
Yes, lordship. That is
Can't
why-
be.
Well, in Rekibuddin case, Lordship,
Let us see.
Lordship.
Let it be open.
Para 15, 16 and 17. Para 15, 16 and 17.
Where is the order? Which page?
Well, page 26.
20?
26, Lordship. And in fact, Lordship, this order has no court at present, Lordship, because the 3 months,
Just one.
Lordship.
Yes, any extension of the suspension is passed?
No, Lordship, in affidavit it was filed, Lordship.
No, that was February.
Lordship. In our affidavit, it
No, no,
stated
come to
that it
page
will be continued,
26.
Lordship.
Come to page 26. That extension order was passed on 5th of February.
5th of February, Lordship.
3 months have gone by.
Lordship.
If there is no extension, this ultimately goes. You have to reinstate him without even the order of the court. You speak to them and tell us at 2 o'clock we are taking it up.
Lordship.
Because if this extension has not been made, even without the order of the court, it will be reinstated automatically.
At 2, Lordship.
Just to- Bring this at 2 also.
Well,
Yes. Yeah, at 2.
Item 3.
This case is almost similar, but here no order has been passed in day. And the petitioner was placed under suspension on 8/8/2023.
Then instruction is related, Lordship. Order 2 weeks time, Lordship.
Several
No,
times.
but
was
it goes,
already-
after that, if you have not extended,
Lordship.
Ajay Chaudhary will apply. You can't save this.
Next to any date, Lordship will obtain the instruction.
No, at 2 o'clock, at best, we can give you time till 2 o'clock because we can't allow you to fill the gap. If at 2 o'clock you can produce anything to show that it has been extended, well and good, otherwise it can't stand.
Item 4.
May I please, Your Lordship? My lord, this matter pertains to promotions to the cadre of assistant engineer from the cadre of junior engineer. They are all eligible candidates, my lord, serving in the cadre of junior engineer for last 27 years. But after a long gap, the DPC had been held, but they have not been considered, my lord. At this stage, my lord, I am praying for a notice because similar kind of case has been issued notice.
Where is this minutes of
My lord,
29?
page 69.
Page
69.
69.
Yes. All cadres have been considered, my lord. Promotion to the post of superintendent engineer. Number 1, if your lordship can see, page 69, annexure 5. Number 1, your lordship will see promotion to the post of superintendent engineer. Then number 2, promotion to the post of executive engineer. But after that, they have not given any promotion to assistant engineer, my lord. 4 vacancies are there. They have gone to there is no provision, my lord. Without considering the promotion, they cannot direct it to recruitment.
But your writ petition is liable to be dismissed. You are asking for quashment of minutes of the DPC without making parties who were given the benefit of promotion.
My
Your
lord,
petition-
nobody has been given to the cadre of assistant engineer.
But then why you are asking for quashment of a DPC which considers the candidature of post which is higher to you?
My lord, they have given a observation, number 4, my lord, page 70. Page 70, my lord, they have given a observation, promotion to the post of assistant engineer, vacant post 4. 4, my lord. It was observed that already 9 posts were occupied by assistant engineer who were promoted from junior engineer, and accordingly, new recruitment required to be done for the vacant posts directly through interview from the degree holders. My lord, promotion 30%.
You're reading where? Page 70 where?
Page 70, para 4, my lord.
Para 4, yes.
Para, promotion to the post of assistant engineer. Vacant post 4 numbers. It was observed that already 9 posts were occupied by assistant engineer who were promoted from the junior engineer, and accordingly new recruitment required to be done for the vacant posts directly
As per
through
the
interview.
recruitment, as per the recruitment policy,
Yes.
what is the
30%, my lord. Page 75 is the recruitment rule.
page
I have-
75?
Yes.
Now, what is the cadre strength of assistant engineer?
My lord, that was 30% of the
Which rule?
My
Which is
lord,
the schedule of the
yes.
vacancies?
Relevant page is page 83, my lord.
83.
83. Para 3, your lordship will be, kindly see, the vacancies to be filled up by promotion of junior engineer shall be so fixed that the promoted engineer shall not exist 30% of the total corresponding cadre strength of the permanent and temporary assistant engineer.
So what is the cadre and what is the manning position of promoted engineers?
It was done long back, my lord,
No, it's not a question of long back.
Mm.
Somebody
But
may have a
I-
tenure in the post of, you see, in PWD, people who have joined PWD as junior engineer,
lordship,
there's a possibility that they will retire as junior engineers.
Yes.
And therefore,
lordship,
they get a benefit of what do you call this assured career progression. Now, the recruitment rule says a percentage. So please tell us if that percentage is the available.
my lord,
the manning
if the
position.
number of posts are 4 vacancies are there, my lord, then
It's not a
30%.
question of vacancy being 4. There may be not 4, let us say 10 vacancies. But it must be in the ratio of what has been prescribed in this
That
rule.
is what, my lord. If it is 30%, then 1 post is there for promotion.
No. It would be cadre strength. If the cadre strength is 20,
Lords. My lord,
The-
that instruction, let them take, my lord.
That instruction is there already. We did his own representation, lordship.
where is that?
Kindly see page 111.
111.
Serial number 3. This is his own representation, lordship.
111.
Paragraph 3, lordship.
Yes.
However, at serial number 10, the total cadre strength of assistant engineer has been shown as 21.
30. So 30 and 9 is okay. Now everything is goes to
30% is 6,
9.
lordship.
no. It will be 30% of
21, it's less than,
21.
Yes.
so already 9%
6.
has been promoted, lordship. So 4 vacancies are there, but this is not open for promotion. This is for direct recruitment. That is the
So your
standard.
petition has to be dismissed.
My lord, in the in the case of same applicant, another petitioner, my lord, this order has.
No,
been
no.
passed.
You see, issuance of notice is not a issue decided.
Lordship, I understand.
But
But,
if you don't have a case, why would we multiply? Why even tomorrow we apply our mind?
My lord, in my humble submission, now the vacancies are there, my lord. And if consideration
No.
for promotion is.
No, this amounts to suppression of material facts. You did not plead in your case that what is the manning position. When we asked you, you said you don't know. And it is the respondents who are now pointing out
My lord,
that
I
in
have
your
just not seen
representation.
this
no.
representation, it has come out, my
You
lord.
see, I have limited knowledge of, my experience in service law is very minimum. All the members in the bar will tell you. I hardly have an experience in service law. If I can find out in 2 minutes, it's not very difficult to take instructions.
Lordship, if I may pray, let it come in the next week, my lord. I'll take some instruction. What can be done.
Okay.
Because they are junior engineers for last 27
Okay.
years.
Your name? Your name?
My name is Udata.
Udata.
Yes.
Her name is Udata and counsel for the petitioner. And also, Mr.
My lord, I'm for respondent number 2, K. Vishwakarma, on behalf of
Mr. A. Biswakarma, done it Sanikasi for respondent number 2, and Mr. For 1, okay. Mr. P. Nayak, done it Sanikasi for respondent number 1. Next para. At the outset, the respondent number, the done counsel for respondent number 1 has referred to the representation of the petitioner at annexure 7 to the writ petition and has submitted that in paragraph 3 thereof, the petitioner has knowledge that the cadre strength of assistant engineer is 21. And as per the service rules, comma, the proportional quota to the post of assistant engineer is, comma, being 30% would be about 6, correct?
Yes.
Post of. Accordingly, it is submitted that in the minutes of the DPC held on 28/9/2022, as the man in position as assistant engineer were 9, which exceeds the service rules. Which exceeds the quota provided for in the service rules. The DPC has rightly not considered the candidature of junior engineers for promotion to the post of assistant engineer. Next paragraph. Next paragraph. Accordingly, the learned counsel for the petitioner prays for his granted time to obtain instructions. List after
My lord, next week any day.
next Friday.
Much of.
Item 5.
Yes.
In this case, the petitioner, your lordship, retired as sub-inspector of Provident Lords.
Heard Mr. has brought up and counsel for the petitioner. The impugned communication dated 8/7/2021 seeking recovery of rupees 3,15,350 from the petitioner as excess money drawn is under challenge in this writ petition filed under Article 226 of the Constitution of India on the ground that the petitioner had superannuated on 31/1/2020. Next one. Issue notice returnable in 4 weeks. Mr. A. Chakravarti, Government Advocate, accepts notice on behalf of
Respondent
respondent numbers 1
2,
to
3, 4,
1 to 6.
1 to 6. 1 to 6.
1 to 6. Mr. P. Nayak, Learned Standing Counsel for the Finance Department, accepts notice on behalf of respondent numbers 7 for Principal Accountant General.
My friend. My friend. Maybe
Yes.
in 8, respondent 8 lots.
Okay, and Mr. D. Bhattacharya, Learned Standing Counsel for respondent number 8, accepts notice for the said respondent. Therefore, issuance of formal notice is dispensed with. However, requisite extra copies of the writ petition be served on them in course of the day. Next paragraph. Till the next date of listing, the recovery is already been
Recovery
made.
is done.
Okay,
Already made.
the recovery already made shall be subject to further orders that may pass in the writ petition.
May I pray for a date, your lordship?
Make a mention.
Lords. Deep you.
Give a date, except mention matter. Give a date. After 4 weeks.
12th of June.
Lords. Oblige.
My apologies.
Item 6.
Done, Lordship.
Yes. We are issuing a notice, we'll give you a short date of 1 week because this suspension order has already gone. But Ms. T. Somlar, counsel for the petitioner. It is projected in this writ petition that the order of suspension dated 4/4/2024 with effect from 17/11/2022 has lost its force on 17/2/2023 on expiry of 3 months. Accordingly, the suspension of the petitioner is assailed in this writ petition filed under Article 226 of the Constitution of India. Issue notice returnable. We are giving 1 week's time. The suspension is already gone.
Not gone, Lordship. Probably, if in the meantime, surset has
No, no.
was issued or not.
No.
No, that is a submission only, Lord.
No, no. You see, is self-evident. You please come to this document. Suspension order is 4/4/2024,
Yes, Lordship.
giving effect from 17/11.
No, Lordship, it's a suspension under 6(2). It's
I
a
understand.
it's a deemed suspension.
I understand.
Even if I do not issue a formal order, Lordship, you will automatically get suspended on the expiry of 48 hours from the suspension
understand.
arrest, Lordship.
But once you pass an order,
Lordship.
the
So this is
calculation-
only a formal order, Lordship. This is only a formal order from the date of expiry of 48 hours. It's a rule, Lordship. It's a deemed suspension. Even if I do not issue a formal order,
The order is passed when 4/4.
no, it's only a formal order, Lordship.
I understand.
It
but
is
the
not even
suspension-
required, Lordship.
Suspension is when you pass an order, that means the suspension operates from 17/11. So 11, 12, 1, 2, 3, 3 months have gone by.
No, Lordship, his arrest was on
17/11, the
10
date of arrest.
yes, 30/11.
Huh?
No, but 30/11 bail,
30/11.
30/11
No.
is
30/11 is the bail order.
bail order.
Deemed suspension would be from the date he was arrested. So 17/11 will
Not from,
assume.
on the expiry of 48 hours, Lordship. Suppose
Okay.
today he is arrested.
Okay,
After expiry of 48 hours, he will automatically get suspended.
okay.
For that, no order is required. This is for only for the office purpose, Lordship. Nothing else, Lordship.
I understand.
Lordship.
I no grievance with that.
Lordship.
But when will, from the date of deemed suspension, when will the suspension expire?
We need to issue one show cause notice within 90 days period. If I am not
So that's why
aware
we are
whether
fixing
that
it
order,
we are giving you 1 week's time. If you have done it, they can produce that.
Lordship. That is why I'm praying for instruction, Lordship, but suspension will remain,
No, that's why you are fixing a short date. We are not staying it right now.
Lordship.
But
That is a
within week
sufficient.
you'll have
Yes.
to show it. Your elections are on, elections are already over.
Lordship.
We are fixing it on 13th or 7 days. If you give you from today, it will be. It will be 17th,
17, Lordship.
correct? You should notice, returnable on 17. 5/2024. First off, Mr. P. Nayak, Learner Standing Counsel for the
All the rest.
respondents, accept notice on behalf of all the respondents. First off, requisite extra copies of the petition be served on him in course of the day. First off, list on 17/5/2024. We give extra copies today only.
Yes, Lordship.
7.
Item 7.
Lordship,
But
My-
Mr. Nayak, I think you and the government appropriate, Mr. Chakravarti, you have to inform the government about the necessity of passing appropriate orders within time on deemed suspension. I think you have to advise the government appropriately.
One OM is already there. Personal department has issued one OM. So as per that OM, we need to issue so forth within a period of 90 days
I understand they're not doing.
in this case.
No, not in this case. It's a general case. This is the second case we are getting it today.
Yes, that is clear.
So you'll have to advise the government appropriately. If they are not following it, there are times when we think that mistakes are purchased. Correct.
Clear.
Yes, item 7.
Lordship, this matter relating to compassionate appointment, Lordship. Lordship, on 15/10/1998, petitioner's father was died, Lordship, and immediately his mother submitted her application, Lordship, as the petitioner was minor at that time, Lordship. Subsequently, in the year 2014, Lordship.
Then you don't have a case.
Died on 1998, Lordship.
98.
Covered by
Yes,
Lordship.
Lordship,
They were
He
the
just
Tiwari case, Lordship.
completed, attained the majority in the year 2014.
There can't be a reservation.
Lordship.
But Syed, as per Syed Khadim Hussain's case, Lordship, of the Honorable Supreme Court, Lordship. In Syed Khadim Hussain's case, Lordship.
It says reservation is there available.
No reservation was given, Lordship, but similar circumstances are also considered.
No. Because you'll have to then file an appeal before the division bench, because I have already authored a
Yes, I have also.
judgment where
They were the Tiwari case. No?
I won't remember the names. No, not Devabrata Tiwari, but this another order of this court where this was deprecated. There's no reservation. Not this Tiwari case.
Lordship. 7.5, Lordship, which is stated, Lordship. The lapse of reasonable period.
No, not this. He's saying about majority. Mr. Nayak, you remember that Supreme Court judgment on this? There can't be a reservation against majority for compassionate appointment.
Sanjay Kumar case.
Yes.
And Santosh. And Santosh.
No, NC Santosh also not there.
State of Manipur versus Supreme Court order.
Supreme Court judgment. If there's no reservation against compassionate appointment for getting
Minor becomes major.
till minor becomes major.
Or style plays it up.
This one, Lordship.
No, this one, no.
Manipur versus-
No.
Suggesting of
The first name is from S.
Sanjay Singh is.
Sanjay Singh is
Sanjay Singh.
Sanjay Singh.
Just pass it on.
Sanjay Kumar is there, Lordship.
Huh?
One Sanjay Kumar is there, Lordship.
Maybe. Yes, Sanjay Kumar.
No.
This is the one I was searching for. Okay. I'm sorry, I have to give you a right of appeal. I have Mr. N.S. Bharwaya and counsel for the petitioner.
Lordship, में a similar matter on 8, my lord has dismissed.
No, this is different.
And this is the West Bengal matter, my lord.
Not required. West Bengal will not apply here.
Sanjay Kumar is applicable, Lordship.
Sanjay Kumar.
Sanjay Kumar, Lordship.
He is given. Mr. Chakravarti is given. Also heard. Mr. A. Chakravarti, government advocate appearing for respondent number 1 and
1
4,
and 4, Lordship.
and Ms. M.D. Bora, standing counsel for the transport department appearing for respondent number 2, 3 and 5. The father of the petitioner died in harness on 15/10/1998, leaving behind his widow and 3 minor children, including the petitioner. Full stop. At the time of death, the petitioner claims to be of 4 years of age. Full stop. It is projected that the mother of the petitioner applied for appointment on compassionate ground on 5/11/1998, but a candidature was never considered. Despite correspondence in the matter. Who is the eldest son? Who is the eldest son of the petitioner, of your father?
The father, Lordship, petitioner is the eldest son, Lordship. Okay.
Okay. But from paragraph 5, we can't learn that, we can't understand that you are the eldest son. Paragraph 5 is not very clear. Next, the petitioner claims that he had cleared his higher secondary examination on 25/2013 and and on 11/12/2014, the mother of the petitioner made a prayer for compassionate appointment of the petitioner. This was followed by another letter dated 5/8/2023 sent by registered post with AD. As the candidature of the petitioner was not considered, the present writ petition has been filed under Article 226 of the Constitution of India. Next, the question as to whether the minor legal heir of the deceased government employee has a right to apply for appointment on compassionate ground on attaining majority has already been decided by this court in the case of Madhumita Bhattacharjee versus State of Assam, within bracket, 2022 bracket within bracket 2, GLT 974 and Latika LATIK Gwala versus State Level Committee, within bracket 2022 bracket 2 bracket close GLT 965, wherein by relying on the decision of the Supreme Court of India in the case of Sanjay Kumar versus State of Bihar, within bracket 2000 bracket close 7 SCC 192, this court had held that there cannot be a reservation of vacancy till such time the claimant becomes a major after a number of years, unless there is some specific provision in the scheme of compassionate appointment. Posted. As detailed discussion by referring to various case laws has already been made in the hearing before referred to writ petitions, the court does not see any reason to burden this order with the replication of the decision rendered in those cases. Full stop. Next paragraph. We may only say that in the case of State of Himachal Pradesh versus and another versus Shashi Kumar, SHI Kumar, 2019, 3 SCC 653. After discussing various decisions on in the matter of compassionate appointment, the Supreme Court of India had reiterated that appointment to any public post in the service of the state has to be made on the basis of principles in accordance with Articles 14 and 16 of the Constitution of India, and that compassionate appointment is an exception to the general rule, and that the dependent of a deceased government employee are made eligible by virtue of policy on compassionate appointment, and they must fulfill the norms laid down by the state's policy. Full stop. Next paragraph. In the state of Assam, comma, the appointment of persons on compassionate ground has been discontinued by what?
31/3/2017.
By,
Till 31/3 it was there, but 1/4/2017.
by notification dated 31/3/2017 by by OM number. What is that?
Lordship, when.
Yeah.
14
Open session. 2017 Lordship.
By notification number FEG full stop 28/2017/26 dated 14/9/2017 issued by the government of Assam, finance within bracket ESTT dash capital A bracket close department, by which scheme for compassionate family pension in lieu of compassionate appointment, in short called as compassionate family pension within bracket CFP bracket close scheme, has been notified. Full stop. It is also well settled that the policy of compassionate appointment, which is in vogue, GUE, would apply. Therefore, the the present case in hand, if you consider the application of the petitioner for compassionate appointment made on 11/12/2014, the said application would be hit by compassionate appointment. Be hit by principle 10 of the office memorandum dated 1/6/2015 on compassionate appointment. However, if the application of the petitioner made on 20/5/2013 by his mother is considered, then the application would be hopelessly barred by limitation, as the father of the petitioner had died in the year 1998. More so in view of the decision of the Supreme Court of India in the case of the state of West Bengal versus Deva Brata, DEDABRATA, Tiwari, TIWARI, and others, AR 2023, SC 1467. Next, therefore, on all counts, the petition is found devoid of any merit and therefore the same is dismissed.
Give to me.
Item 8.
You take back your citations. Yes.
Visible petition is the disabled person. Appointment order has been issued and he accordingly joined subsequently.
Oh, yesterday you gave us, the day before yesterday, you gave us trouble.
Yes, my lord, actually, I'm extremely sorry. I was out of station due to my father.
Yesterday we got it listed because you moved the matter and we find that in the prayer, your only prayer is for extension of the validity without any other relief claimed. That writ petition can't be allowed.
My
A
lord,
writ petition only asking for extension of validity of a select list can't be entertained.
because my lord, this honorable court directed me to challenge the disabled report, my lord. That has been,
No, but I don't know, independent of any other relief claimed, I don't find that the writ petition is maintainable. You've been asked to do so, but I still don't see any reason to entertain that writ petition seeking the only relief of extension of the validity of select list.
yes.
Because that will be allowing the court to we'll come to it when it gets listed, we'll then see it. Here, what is your prayer?
I challenge that. Permission
This will
order.
be same. This will be same. Which is that earlier order we passed, in which case?
My lord, it was on 14, it was fixed, my lord. On 14,
Give us the writ petition number.
yes.
We'll find it out. Same order.
Case number 2.
Mr. S.K. Roy, counsel for the petition. Mr. For government, Mr. Chakravarti will appear. Mr. K. Chakravarti, government advocate, appearing for respondent number 1 and 2. Social welfare, you are there. Social welfare who's appearing?
My friend.
You are there. Your name? P. Jain, then counsel for standing counsel for respondent number 3. Health, your name? Your name? Aidas. Then counsel appearing on behalf of Mr. D. Upamanyak, standing counsel for Health Department, representing respondent number 4. State level recruitment, you are there. Mr. V. Chaudhary. V. is Vikram, huh? V. Chaudhary, standing counsel for respondent number 5.
Yes.
Now then health will be 4 and 4, 7 and 8. 4, 7 and 8. We can submit for 5. Taxes.
I'll be appearing for respondent number 6.
Okay. Okay. Mr. A. Shalia, and standing counsel for respondent number 6. Accepts notice on behalf of all the respondents. First of therefore, issuance of formal notices dispensed with. However, requisite extra copies of the writ petition will served on them in course of the day. The same order like earlier. Only the names given. This benchmark disability is
30 here on medical.
visual impairment in both eyes with 40% disability. I'm repeating again. Visual impairment in both eyes with 40% disability. Okay. Same order, same interim order. Give the writ petition number.
Item 9.
Yes, Mr. Samara.
My lord, please your lordship. My lord, this is in fact the second round of litigations because of the fresh order passed by the government, my lord. The dispute between the petitioners and the government was, well, there are two departments in the state of Assam. One is the Assam Police and the next is the Director General of Civil Defense and Home Guards. Both are under the government of the Home Department. There are the cadres in the.
You made the list of dates so large. By the time I read,
Well,
and
because
come
of
to
the
the end,
fact that this is
I
the second
forget
round
first
of
part.
meeting.
No, that's okay. But by the time I start reading the synopsis,
Well.
by the time I end, I forget the first part.
But sorry to say, sorry for that, but sometimes, my lord.
No, that's okay, but tell us what is the issue involved?
Issue involved is that, my lord, one cadre, my lord, in two departments. The rest of the cadres are, there is no dispute in pay parity. In one cadre, that is the APS junior grade in Assam Police. I am for the, now these petitioners are from the Director General of Home Guards and Civil Defense. And junior staff officer, assistant commandant, chief instructor, district commandant, these are the posts which are equivalent to the APS junior grade. Assam Police Service junior grade. Earlier, we used to get the same pay. Suddenly, from the year 2010, the pay parity, the pay structure has been changed only against this cadre. Rest are same.
But on this, we can't do anything. It has to be sent to the pay.
No, it has gone through. It has gone through. It has referred to the pay anomaly committee. Pay anomaly has given some observation. Then the impugn order was passed. It was placed.
Issue notice. In the
My
paper.
lord, issue notice.
The Mr. Samuel and counsel for the petitioners. The petitioners who are appointed under the Home Guard Service of the state are seeking pay parity with
Disparity is only on one cadre. My lord. That your lordship can see at page 20.
no, you are Home Guard. You
We are
seeking
from
pay
the Home
parity
Guard
with
departments.
huh?
We are from the Home Guard departments.
You are asking for pay parity with whom?
Assam Police Service junior grade.
Assam Police Service Junior Grade.
Yes.
And accordingly, this writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks.
Serve the extra.
Mr. Who's appearing for whom?
I am appearing for all the respondents. Lord.
Okay, Mr. A. Secretary and Government Advocate, accept
One-
notice for respondent number
3 has to be.
One, two.
1, 2, and 4.
1, 2, and 4. Lord.
Finance, you'll Mr. A. Shadia, and it's manifest for the Finance Department, accept
Three.
notice for respondent 3. Just right. Next, issuance of formal notice is dispensed with. However, requisite extra copies of the writ petition be served on them in course of the day. Next, pendency of the writ petition shall not be a bar for the respondent authorities to examine the grievance of the petitioner.
Obliged. But during the course of the day, can it be on Monday?
Okay, by
Monday. Because tomorrow is second Saturday.
13/5. Okay.
Obliged.
Item 10 for admission.
Please do lordship.
Yes.
Lordship, I am for the railways, lordship.
Yes.
Lordship, I am extremely sorry, lordship, I in the wrong file. Lordship.
Next week then. Next week.
My lord, if lordship may allow, my lord, as far order dated 25/9/23, there was a direction to provide the mark sheet in a close. My lord, may kindly come to 25/9/2023, madam.
5/9/23.
Yes, madam.
In seal cover.
Yes, madam.
My lord, in these regards, I have a small submission before your lordship. So far, the last order, lordship, my learned friend is submitted. Actually, the matter is not that. The court has direction for the mark sheet, lordship. The case is not for mark sheet. Case is for the petitioner has
No,
a
that
right
I don't
to.
know. You see, once there is an order of the court,
That
I'm
is
not
true.
sitting in appeal over that order.
That is true. That
So
is
either
there.
you comply or you file an application for modification.
That is their lordship.
Hmm.
That order we have complied. That order is with us. That will produce before your lordship.
Yes.
But my respectful submission is, lordship, the matter is not related with this. Matter is some other else, lordship, because the petitioner has no right at all to participate in the
Don't tell us. This is something I have been,
that
I've been
has to
showing
be
you
that
for
is required.
hundreds of times. You look at this, this book.
Lordship is true. That is
No,
that is
you
correct.
be satisfied. Don't go out of this court dissatisfied. That on question of law I have not been heard. He's showing you this.
That is
You
true,
have some
lordship.
idea. If that is true, then why you are making that submission? You know, read 165. I'll compel you to read it.
We have that. We have the order with us.
Please read 165. You can't refuse the court not to read.
Lordship.
If you do it, there will be other consequences. Read 165 loudly so that I can also understand.
Yeah, lordship. Judges power to put question or order production. The judges may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases, if in any form, at any time, of any witness or of the parties about any fact relevant. That is true, lordship. I agree with lordship.
Please read, please read.
Relevant or irrelevant, and may order the production of any documents or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given.
Correct. So that's all.
That is all.
Other reading is not required.
Yeah.
So even if I'm out of my mind and asking you to produce a document which is irrelevant, please do it.
That is true. We have lots.
Then don't
Well,
make an argument.
Yes, lordship.
You're not
Well,
permitted to argue after that.
My lord, earlier direction, as per the direction of this court, I have produced the result of the
Where is it? It's not here.
result in original, my lord, in seal cover.
My lord, may kindly peruse order dated 29/2/2024, my lord.
29 to 24.
Yes, lord.
This is the original. লিখা আছে।
But the seal cover is not there.
My lord, as per the direction of this honorable court, we allowed him to sit in the exam, and
The result of the petitioner was kept in a seal cover and produced it, but on that day, my lord, the honorable court could not
Oh, that is the same document that he had placed it on 29 to 24, my lord.
and thereafter to clarify whether he obtained the pass mark or not. And thereafter, I obtained the instruction.
Yes.
It's a single copy, my lord, instruction at dated 20 March 2024.
20 March 2024.
Yes, my lord.
So the petitioner has passed.
Pass, my lord, obtained pass mark.
Obtained pass mark.
But next page, my lord, registration number. As
Yes.
per the direction, we have to put the registration number as Deepak 1.
Okay.
Because he already obtained national certificate in the same trade. That is why we rejected his candidature to reject to appear in the exam. Same trade, my lord, filter trade. And he cannot allow to sit in the same trade, my lord.
Where is that? Where is that bar?
Bar, my lord, in Apprenticeship Act, my lord, it is
Apprenticeship Act.
3(2)(b), my lord.
Apprenticeship Act.
My lord, this is the copy, my 3(2)(b).
This is rules. Rules we are having.
Rules.
Yes, 3(2)(b).
3(2)(b), my lord. Oh, 3(2)(a), my lord. 2(a). No engineer, my lord. A vocational certificate holder who had attained or job experience for a period of 1 year or more after attainment of this qualification shall be eligible for being engaged as an apprentice under the Act. He obtained national certificate in filter trade from Maruti Suzuki. His certificate is annexed in an
Standard education.
deed petition.
Trade faculty is also the remaining qualification. It says no engineering graduate or diploma holder or vocational certificate holder
Yes.
who had training or job experience for a period of 1 year or more after attainment of these qualifications shall be eligible for being engaged as an apprentice under the Act.
Yes.
So you see, his case is that he never completed it. Before that, he went away and therefore you've taken a step. He did not complete 1 year.
Yes, my lord.
Then
One of the
how-
earlier occasion he obtained the national certificate.
Where is that?
At a page, my lord, page 25 of the writ petition. Registration number is there, my lord. National Apprenticeship Certificate.
So he did it for 1 year
Yes,
and therefore he applied for the second time.
the second time.
Then he applied for third time.
No, this is the first time.
Okay.
He obtained certificate for the first time from Suzuki Maruti in filter trade.
Okay.
This is certificate issued.
But I don't get it. You have not, you have terminated him on the ground that he did not complete. That's what I understood.
Yes. Because he is not entitled. Because he already obtained national certificate on the same trade.
Okay.
And that is why in our affidavit in opposition
Yes, which
at
page?
page 65, my lord. As 65.
No, no, okay. No, you'll have to start the argument first.
Yes, my
So
lord.
what is your case? Yes.
Yes, my lord. My lord, the fact of the case which is involved here, my lord. But
Yes.
my lord, may kindly come to page number 27.
27.
Of my writ petition, lordship.
Yes.
My lord, this was a notification or the application which was issued by the Railway Authority for engagement of the apprenticeship under the Mechanical Works of Dibrugarh under the Apprenticeship Act 1961 and Apprenticeship Rule 1962. My lord, may kindly come to page number 9, lordship. My lord, page number 28.
What is the name of this letter? 27?
My
What is
lord,
it called?
it is from the office of the Chief Workshop Manager.
What is it called?
Engagement of passed out ITI candidates as act apprentices in NF Railway Mechanical Workshop Dibrugarh.
Yes.
My lord, the next page, page number 28.
This is for which period?
My lord, the entire period of apprenticeship is for 1 year, lordship.
Yes.
My lord, may kindly come to page number 28. My lord, point number 9, qualification. Matriculation or 10 in 10+2 examination system and having ITI certificate from the institute affiliated to NCVT compulsory in relevant trade. Copies of all certificate, proof of date of birth, educational, technical qualification certificate, ex-serviceman certificate, all these are the qualification requirements.
Yes.
Now, as per this qualification, my lord, I have the ITI certificate. I have done my 10+2 and I have attached all the relevant documents regarding my qualification with the application.
Yes.
My lord, may kindly come to page number 30.
Yes.
Point number 17, my lord, the heading says conversing in any manner will be disqualifications of the candidate. What is the manner on which disqualification can happen after the required qualification? Application on receive after closing date will take, my lord, this is the thing, 17 and 18, lordship.
Yes.
Now, I will go to point number 19, mode of selection.
Yes.
Engagement of ag apprenticeship will be done only on the basis of marks obtained in matriculation examination in 10+2 examination system and having ITI certificate from an institute affiliated to National Council for Vocational Training is compulsory. No extra weightage shall be granted to candidate having higher education. Well, this point has to be marked, having higher qualification. Selection will be done on pro rata basis in proportion to the application received from various board university. Candidates equal to 1.25 times of the number of slot act apprenticeship shall be called for verification, original testimonial, and their physical fitness. Well, these are the
mode of selection. My lord, kindly come to page number 31.
Yes.
Application having any of the following deficiencies, discrepancies, or irregularities will be summarily be rejected. These are the grounds. If I keep on referring all this 12 point, my lord, the point that they have raised at this stage doesn't fall under any of this grounds. Because once you give
not a sustainable argument,
my lord,
because there cannot be an what you call once there is a act or a rule prescribing something
Yes.
which is statutory,
yes, lord.
then it's not required to be prescribed. No law will say, or no appointment orders will say, after getting an appointment, you cannot murder. After getting an appointment, you can't steal.
Yes. Yes.
So therefore, you can't say that, okay, vigilance inquiry, why it was conducted, there is no condition in my appointment letter that you can't do any mischief, is not given in the appointment letter. So therefore, I have committed mischief. That can't be an argument.
My lord, then lordship may kindly come to page number 32.
32.
This 32. My lord, what I have understood that since they have placed these rules before this honorable court, the selecting committee is aware about this particular act, and they have definitely gone through and scrutinized my document. After that, my lord, to Deepak, it was sent a call letter for document verification and medical examination of passed out.
You see, there can't be an estoppel against statute. Once there is the statute prescribes you, second time, even if you pass,
Yes, lord.
it doesn't entitle you to a certificate because of the bar created under 3(2)(a). It's a question of law. We can't
No, my lord, the
alter that.
question is, my lord, what I have done earlier, I have done apprenticeship. I was doing apprenticeship. It was not my job. I have done my apprenticeship under Maruti Suzuki. The same apprenticeship I have applied here. After scrutinization, they have found me eligible and they had
But
given me.
once it's the same trade, the bar is absolute.
Yes.
So even if your this answer these are disclosed, but the statutory bar will prevent you to get any benefit.
My lord, if there is a bar made by the statute, my lord, my normal understanding goes, my lord, there should be a time frame fix saying that within this period of time, scrutinization of documents will be done. And after that, if you are not found it eligible, you will be rejected. I was allowed to undergo training for 11 months, my lord. 12 months was the total period of training. On 11th month, you found out that no, you are not eligible because you have done apprenticeship earlier. Now, if there is a law, that law should have a specific time that can be applied so that, my lord, the petitioners have given 11 months of his life, lordship. And these are ITS
You
candidates.
see, it may sound very harsh to you coming from the court, but that is the hard reality. The harsh fact is that if they have committed wrong, you can merely sue for damages. But we can't say that the act will not have an application just because you have, for the second time, you have almost completed your course. The law bars it. We can't direct the respondents to violate the law. That power the writ court will not have. So we have to close this writ petition. But you had played for an adjournment, so we adjourn the matter.
No, lordship, as you lordship. Lordship.
My lord, for that reply, my
But
lord,
you'll have a grievance.
Lordship.
But you will have a grievance that I
As
paid
per-
for an adjournment, the court.
My
did
lord,
not allow. Okay.
As per notification, railway, they entered into agreement. My lord, at page 37,
I everything is
37.
37, my lord. And as per clause 20, agreement of training, it should be executed. But here 12, clause 12.
Heard Mr. K. Vishwakarma and counsel for the petitioner. Also heard. You're appearing as CGC in the matter.
My lord,
You're appearing as CGC in the matter for respondent number 1.
no, my lord, earlier, my lord, I appeared on behalf of the railway also, and CGC entrusted the case upon me.
So he's also,
My
you're
lord,
also.
he was previously, he was here,
Yes.
appeared.
You see, also heard Mr. A.K. Dattar under CGC along with Mr. D.K. Dey, the counsel for the respondents. Next one. On 17/10/2014, an employment notice was issued by the chief workshop engineer, NF Railway, within bracket respondent number 4, inviting application for engagement of ITI passed candidates as apprentice in the trade of inter area, in the trade of fitter. At the NF Railway Mechanical Workshop, Dibrugarh. Stop. The petitioner had offered his candidature and along with other documents, he had submitted a National Apprenticeship Certificate issued by the National Council for Vocational Training and Maruti Suzuki. Full stop. The petitioner got selected and by a communication dated 29/10/2015, the petitioner was directed to appear before the principal, what is STC? State Training Center.
Yes, ma'am.
What is the full form? STC?
Street Training Center. Lordship.
Huh?
It should be Street Training Center. It should be Street Training Center. Lordship.
State Training Center, Bangaigaon. So stop. After having undergone training for more than 11 months, on payment of stipend, the apprenticeship of the petitioner was terminated by notice dated 6/9/2016 with effect from 14/9/2016. So by that time, the petitioner had completed 11.5 years of training and a minuscule period of 6 months had remained. Full stop. Next para, it was projected that by the said action of the respondents, as the petitioner was prevented from appearing in the final examination to be held in April 2017, and as the petitioner was directed to deposit 3 months in the last 3 months stipend at the rate of rupees 5880 per month, aggregating to rupees 17,640, the petitioner has assailed the termination letter dated 14/9/2016. Next para. The learned counsel for the petitioner has submitted that the petitioner had disclosed all material facts when applying for apprenticeship training. And that there is nothing in the employment advertisement which empowers the respondents to terminate the apprenticeship after having joined there. His training could not have been terminated and recovery of stipend could not have been made. It is submitted that the defense taken by the respondents to the effect that there is a statutory bar under Rule 3 within bracket 2 within bracket small b of the Apprenticeship Rules, 1992, was not disclosed to the petitioner either in the employment advertisement or in any other communication before the commencement of the training. So accordingly, it is submitted that the petitioner, having undertaken the training for the entire period except for last 6 months and had a reasonable expectation of being absorbed in the establishment of the NF Railway, it is submitted that the pair made in this retribution filed under Article 226 of the Constitution of India be allowed by quashing the termination notice dated 6/9/2016, giving effect to the termination on and from 14/9/2016. Next paragraph. The learned counsel for the petitioner has submitted that pursuant to interim orders passed by this court, the petitioner was permitted to sit in the final examination, which was scheduled between 6/4/2017 and 12/4/2017. So, next paragraph. No, not the 6, same paragraph. So it is also submitted that pursuant to the order of this court dated 11/9/2023, the respondent authorities were directed to produce the result of the petitioner in a sealed cover, and as per the no, sorry, no, not 11/9, it's 25/9. On 29 to 2024, when the sealed cover containing the result was opened by the court, comma, the result sheet, from the result sheet, it could not be deciphered whether the petitioner has passed or failed in the apprentice examination, and not the learned CGC could enlighten the court on the point, and therefore the matter was deferred. Next column. The per contract, the learned CGC as well as the learned counsel for the study counsel for the respondents was referred to the statutory bar created under rule 3 within bracket 2 within bracket B. Sorry, A, not B, it will be A. B within bracket 2 within bracket A of the apprenticeship rules 1992. We submitted that because of the statutory bar, notwithstanding whether the petitioner was successful in the examination or not, comma, the legal bar would prevent the respondents from issuing any to engage the petitioner as an apprentice. Next paragraph. It is also submitted that while undergoing the, while allowing the petitioner to undergo the apprenticeship training, comma, a contract agreement was signed with the petitioner, which expressly provided that the where is that? Which page? That agreement you referred? Which page?
Agreement, my lord. That page. Agreement. Agreement at page, my lord, 37, relevant portion. Mode of contact of apprentice, major and minor apprentice. 37, clause 12.
37.
37, relevant portion. 12, my lord. With the employer, apprentice cousin,
Petitioner and the employer.
surety solemnly declared that we have read the Apprenticeship Act 1961 and Apprenticeship Rule 1992 regarding the contract of apprenticeship.
The
training.
petitioner would abide by the Apprenticeship Apprentices Act from 1961 and Apprenticeship Rules 1992. The act is Apprentices CES and Apprenticeship Rules 1992. Next paragraph. It would be relevant to quote the provision of Rule 3 of the Apprenticeship Rules, 1992. Next paragraph. From reading of clause A of subsection, clause A of subrule 2 of rule 3 of the apprenticeship rules, 1992. We find that there's a statutory bar for engagement of those persons as apprentices who had training or job experience for a period of 1 year or more. Post roll. Yes. The petitioner has annexed to the writ petition a national apprenticeship certificate issued by the secretary, comma, issued by the Government of India, Ministry of Labor and Employment, comma, National Council for Vocational Training, which is jointly signed by the Secretary, National Council for Vocational Training, and Secretary, State Council for Vocational Training, where the petitioner had passed the prescribed trade test held in October-November What is the date?
Lord, I think it should be 2010.
2010.
Yes, because the period mentioned is from 19/8/2009 to 18/8/2010.
No, 10, 2010. On completion of his training at Maruti Suzuki India Limited, Gurgaon. Next paragraph. Therefore, going to the statutory bar as referred above, even if the petitioner has turned out to be successful in the sessional marks.
This is the,
what is it?
Lordship, this is the final examination. Actually, my lord, if may allow.
Yes.
My lord, maybe I heard it wrong, my lord, whether the period is mentioned is 11 years something. It is actually, my lord, 11 months.
11 months, I
Oh,
said.
yes. My lord, this is the last, this is the final examination, Lordship. And this is the final mark sheet which is to be given to me after completion of the period of apprenticeship.
Although in this case, the petitioner is shown to have passed out the 105th AITT. Comma. But the said pass certificate would not be sufficient to give any benefit to the petitioner in view of the statutory bar of rule 3 within bracket 2 within bracket A as of the apprenticeship rules as referred to above. Full stop. Moreover, comma, in view of the statutory bar, comma, the petitioner is otherwise found disentitled to a second national apprenticeship certificate on the same trade of fitter under such circumstances, comma, notwithstanding that the petitioner has cleared, notwithstanding that as per the documents produced, comma, the petitioner is shown to have passed out the 105th AITT. But the candidature of the petitioner in the said examination in being not sustainable, comma, it would be open to the respondent authorities to recall the result of the petitioner. Next column. The direction contained to the respondent authorities to recall the results of the petitioner is due to the fact that it is pursuant to the interim orders of the court that the petitioner was allowed to appear in the final examination, and by the orders of this court, comma, the result of the petitioner has been brought on record by in a sealed cover. As made, the court does not find this to be a fit case, comma, the petitioner stands dismissed. The result sheet produced by the learned CGC in the seal cover is returned with, it is returned.
My lord, may I take back the original?
Original I don't have, you just check it up. Original we don't have, we have this on this. Original we don't have, you gave us the original, no?
Original, my lord, original silk cover is there, my lord. In
Where?
silk cover.
The document now you produced,
Yes, my lord.
and that we are returning it to you.
I oblige, ma'am.
We'll take a break and come back.
May I please my lordship? May I please my lordship?
Reply file na kore. Please kore.
My lord, the petitioner Devendra Singh, he was now posted at Mount Abu Rastan at the time of posting on Andhra Pradesh, 19708. He was rebuked by his commandant.
My lord, in this case, Lord, is a record to anybody. My lord, wide order dated 9/8/22, records were called for, Lordship. Lordship, we have received the record, but they have taken back. Lordship, I required some time to produce the records, Lordship. By 9/8/2022, records were called for.
Okay,
Then, sir, we have received it, but thereafter they have taken back the record, Lordship. So I require some time to produce the record, Lordship.
how much time?
Lordship, in 2 weeks, Lordship. Let it be in the month of June, Lordship. Because I will be out of station for some days, Lordship.
3rd of June?
Lordship.
Okay, both sides are represented. Mr. S.S. Royal and CEC submits that the original records which were called for by order dated 9/8/2022 was provided to him, but for some reason the respondent authorities have taken it back. He prays for his granted time to produce the said records. Next paragraph. Having noted that the petitioner is challenging the orders of the disciplinary and the appellate authorities which were passed in the year 2009. The respondent shall produce the relevant records without fail. Next, respond 3/6/2020. 24. Just a moment. You have seen the affidavit filed in the matter. At page 15, your affidavit.
Yes, my lord.
The affidavit appears to be defective. To take a call, I can just only point it out. You see at the time of hearing.
Lordship, my affidavit. Lordship.
No. The affidavits in support of the writ petition. You just have to take your time and check it out, but your affidavit appears to be defective.
Item 13.
Case in brief is that, my lord, at the time of under consideration of the promotion.
You have the office memorandum, who is the government advocate here?
Yeah, I got that official.
You got it?
Yes.
Okay.
So
That is 9th May 2006.
Yes, yes.
Okay. Okay, a copy is here. Okay.
Your lordship got it.
Yes, a copy is here, available here.
Same, my lord, your lordship will kindly see that number 3.
Just one.
This is on the basis of Janaki Ram's case.
Three.
My lord.
Serial number 3.
First is, my lord, this 1, 2, paragraph 2.
Yes.
Government service under suspension. She was not under suspension. Government surveyed in respect of whom a charge sheet has been issued. There is no charge sheet and the disciplinary proceedings are pending. There is no that. Government service in respect of whom prosecutions for a criminal charge is pending. It also means when a charge sheet has been filed. Yeah, Supreme Court judgment to that effect. And this is based on Janaki Raman,
yes.
Janaki Raman's case. So, your lordship, I'll take it to facts of the case is that she was working since 2013 as junior grade officer, and 2017 some problem arose in connection with some mutation, my lord. But anyway, that's a different chapter. And 2018, my lord, a complaint was filed, and subsequently 2022, a police case was raised. And now the DPC was held in March 2020. Your lordship may kindly note these things. Well, this is verbal information to me, and impugned notification was issued on 17/4/2020, promoting her batchmate to senior grade 2. That your lordship will find at page 13. And her name has
So
not been
you are trying to say that the
under date.
consideration of promotion was not made under seal cover.
It was seal cover, but it cannot be made under seal cover because there is no charge sheet, no disciplinary proceedings, no charge sheet in criminal case. So therefore, it cannot be kept under seal cover. This is my lord.
Okay.
So therefore, my lord, and they are saying, my lord, prosecution sanction has been given. So therefore, we have kept it under seal cover, and they have taken the plea under office memorandum dated 9/5/2006, which I have shown. My lord, your lordship will kindly see this. In regard to disciplinary proceedings at page 19, a show cause was issued and a reply was given on 11/8/20, that is at page 22. Now at page 32, your lordship.
Yes.
Now page 32, your lordship will kindly see. It says paragraph 5, page 33.
33.
Yes, paragraph 5. This is an affidavit on behalf of respondent number 2, Secretary Revenue. This is not important.
This is affidavit of?
The Secretary Revenue, my lord.
No, it is one number
2. I'll just read this. That paragraph 5, may I read? That with regard to statements made in paragraph 6 of the instant writ petition, the deponent begs to state that it is a fact that a show cause notice was issued to the writ petitioner by so and so based on the allegation that while she was a circle officer, Tinsukia Revenue Circle, she entered one data on 9/12/2017 in the name of Srimati Sumitra Bora, reflecting as owner of land measuring so and so on the basis of purchase and possession by the order dated so and so in place of Bharat Mura. However, they said data was not available in the computer system prior to 9/12/2017. The deponent further says that it was intimated by the Deputy Secretary to the Government of Assam that a prosecution sanction has been accorded against the writ petitioner in CR case number so and so as sought by the court of the judicial magistrate. So therefore, prosecution sanction has been accorded. I think the according date is 2019. 21/11/2019. That your lordship will get it at page 40. Page 36, my lord. Page 36. Sorry, my lord, I have given the, in my affidavit reply, paragraph 5. Prosecution sanction accorded on 21/11/19. Paragraph 5 I have stated. Page 38, last but one paragraph.
You lodged an FIR.
No, they lodged it. I was a circle officer at that point.
This is affidavit
No,
in,
we lodged an FIR against them.
this is affidavit in reply.
Yes, yes,
That
Yes,
is
yes.
affidavit in reply must be you.
yes, yes.
You are saying that you
Yes.
lodged an FIR.
We lodged an FIR against that officer, that Mandal. Because my case is not that Mandal, Lot Mandal has manipulated the whole. I'm just showing my lord the date, 21/11/2019. The prosecution sanction has been accorded by the government. And that is the reason for keeping the whole DPC under seal cover. Page 40, if your lordship comes to affidavit.
Just a moment.
by-
I'm not being able to follow. Just a moment. Where is that document of prosecution sanction prosecution? Where is that?
Page 30,
30.
yes, 30. Thirty-one is the paragraph, a page, my lord, last paragraph. Now, may I
No, no,
take-
just now, just now. I'm being able to follow. Where is the order of the CGM? Can you, is it available?
CGM is there, not clubbing both the case. Variation not there. Page 48, I think. Sorry, mother, page 42, 50, man.
Page
50.
50.
There were two cases. One is complaint, one is PR case, both the clubs.
No, no,
cases
no.
are- Yeah.
No, not this. Raji. Raji. C 197.
Sanction, yes.
Read that.
Yes.
Please read that.
Where-
197.
Where any person who is or was judge or magistrate or a public servant not removable from his office save or with sanction of the government is accused of any offense alleged to have been committed by him while acting or purporting to act in the features of his duty, no court shall take cognizance of such offense except with the previous sanction.
So
And
therefore,
Yeah.
now you got it.
Yes.
Has to be previous sanction. There can't be a post sanction of a prosecution.
But in this case, my lord,
But it won't stand. You'll have to go for questioning otherwise, because otherwise, you see, it's a situation where you accepted it. Once you accepted, the fact that the government is aware of a prosecution being instituted against you is a knowledge which is there with the authorities. If I think you'll have to take a call, you'll have to please check up if
No,
under
but
those facts.
In my case, this case, my lord, this case is a case of different nature. That quashing, etc., that they will do it in regard to the criminal case pending, which is pending now. Charge sheet has not been filed, I think. Charge sheet has not been filed as yet.
No, charge sheet will never be filed because it's a complaint case.
Yeah, no, even PR case is also there.
PR
Both the
case
cases have been.
no, PR case
cases
is
have
filed
been-
by you.
No, by them. Malad, there are two cases. I filed a complaint against the lotman, saying that, Malad, whatever has been done, it has been done using my key by the lotman. That's a separate case because the allegation is that I have mutated the name of some other person instead of the earlier owner. And that I have done it wrongly, which I have immediately when the objection came to me, to the petitioner, she has corrected it. And besides this, my lord, besides the correction, I have also lodged a complaint, FIR, before the authorities against the lot mandal, saying that it is actually whatever has been done, it is done by the lot mandal, not by me, by using the key provided to me. So this is one. Second is, my lord, the person against whom I have mutated the land. So they were the original owner. They filed a complaint in the year 2018. Subsequently, they have also filed an PR case in the year 2022. So both the cases were tagged together.
Okay.
That is the order at page 40, 42, 51. So this is the position of law. So now my question is, my lord, so if at the relevant time, as your lordship got it, page 50, this is what I was asked to, my lord, to provide what has happened to both the cases relating to the same complainant against me. So this has been tagged.
Okay.
So now the basic question is, now what they have said is, your lordship will kindly see page, I think 36. Yeah. Sorry. Page 40, my lord, affidavit in opposition filed by the respondent number 1 to 4.
Yes.
Paragraph 6 at page 42. Deponent begs to state that the officers recommended by the Departmental Promotion Committee for promotion to senior grade 2 have been promoted accordingly. But so far as the petitioner is concerned, the Departmental Promotion Committee decided to keep its decision in seal cover due to prosecution sanction. This is the nutshell this is the problem. So can you do this? So now your lordship will kindly, your lordship has seen this office memorandum. They have taken the plea of office memorandum, subsequently which is reflected in the order sheet. It says, it discusses about the judgment in Janaki Raman case and instruction is at page paragraph 2. Paragraph 1, your lordship will kindly see. Have also noticed the judgment dated so and so of the Supreme Court of in Union of India versus K.V. Janaki Raman. As a result of the review and in supersession of all the earlier instructions on the subject, the procedure to be followed in this regard by the authorities concerned is laid down below. So number one is when one is under suspension, when charge sheet is issued. Third one, they are saying the prosecution sanction has been issued. So therefore we have kept it in the DPC. Now third is your also will read it again. When government servants in respect of whom prosecution for a criminal charge is pending. It means, my lord, charge sheet has been filed. So I'll point out that your lordship will kindly see 2000 judgment. 1991 486. Paragraph 16. Paragraph 16. May I read?
Yes.
On the first question, as to when for the purposes of the seal cover procedure, the disciplinary / criminal proceedings can be said to have been commenced. The full bench of the tribunal has held that it is only when a charge memo is in a disciplinary proceedings or a charge sheet in a criminal prosecution is issued to the employee that it can be said that a departmental proceedings or criminal prosecution is initiated against the employee. The seal cover procedure is to be resorted to only after the charge memo or charge sheet is issued. This is very clear. The pendency of the preliminary investigation prior to that stage will not be sufficient to enable the authorities to adopt the seal cover procedure. We are in agreement with the tribunal on this point. The contention advanced by the learned counsel for the appellant authority that when there are serious allegations and it takes time to collect necessary evidence to prepare and issue charge memo, charge sheet, it would not be in the interest of the purity of administration or to reward the employee with a promotion, increment, etc. does not impress us. The acceptance of this contention would result in injustice to the employees in many cases. As has been the experience so far, the preliminary investigations takes an ordinary long time, and particularly when they are initiated at the instance of the interested persons, they are kept pending deliberately. Many times they never result in the issue of any charge memo, charge sheet. If the allegations are serious and the authorities are keen in investigating them, ordinarily it should not take much time to collect the relevant evidence and finalize the charge. What is further, if the charges are that serious, the authorities have the power to suspend the employee under the relevant rules, and the suspension by itself permits a resort to the seal-covered procedure. The authorities thus are not without a remedy. It was then contended on behalf of the authorities that the conclusion number 1 and 4 of the full bench of the tribunal are inconsistent with each other. Those conclusions are as follows. Consideration of for promotion selection grade crossing the efficiency bar or higher pay scale of pay cannot be withheld merely on the ground of pendency of a disciplinary proceedings against the officials. Now, paragraph 7, there is no doubt that there is a seemingly contradiction between the two conclusions, but reads harmoniously, and that is what the full bench has intended. The two conclusions can be reconciled with each other. The conclusion number 1 should be read to mean that the promotion, etc., cannot be withheld merely because some disciplinary or criminal proceedings are pending against the employee. To deny the said benefit, they must be at the relevant time pending at the stage when charge sheet or charge memo has already been issued to the employee. Thus, there is no inconsistency in the two conclusions. Now, your lordship may kindly see paragraph 32. In this case, no charge sheet was served on the respondent employee when the DPC met to consider the respondent's promotion. Yet, the seal cover procedure was adopted. The tribunal has rightly directed the authorities to open the seal cover, and if the respondent was found fit for promotion by the DPC, to give him the promotion from the date his immediate junior Sri so-and-so was promoted pursuant to the order dated so-and-so. The tribunal has also directed the authorities to grant to the respondent all the consequential benefits. The tribunal has further stated in the impugned order that this order would not mean that the disciplinary proceedings instituted against the respondent employee should not go on. We see no reason to interfere with this order. The appeal therefore stands dismissed. In the circumstances, the case, however, there will be no order of discourse. So now, therefore, when there is no charge sheet or there is no disciplinary proceedings initiated by filing of a charge memo, you cannot, in a DPC, you cannot keep the promotion of anybody, my lord, under seal cover. Now, your lordship kindly say 2013 will make the case more clear. What is the meaning of government servants in respect of whom prosecutions for a criminal charge is pending? 2013 4 SCC 161. Paragraph 3 1. May I read? Just a moment. Paragraph 3 1. This is an important case. It is based on the Janaki Raman case only. I'll read this to clarify the Roman 3 of paragraph 2 of the office memorandum dated 9/5/2006. Paragraph 3. May I read? Yes. It was alleged by the appellant herein that during the year 94-95, while the respondent was working as assistant accounts officer in the central stores accounts in the office of the financial advisor and the chief accounts officer NF Railway Maligaon, he committed gross misconduct in the matter of checking and passing the bills various firms involved in manufacturing and supplying the of cast iron sleeper plates to NF Railway. For the said acts, 4 memorandum of charges were issued to the respondent, out of which 2 were issued on so and so. Only charges were issued, charges were not framed. So paragraph 4, based on the similar charges in the year 2004, CBI lodged 11 FIRs against the respondent herein on different dates under section so and so, so and so, so and so, but no charge sheet. Now, number 5, my lord. By office order dated 2003, the batchmates of respondents were promoted. Being aggrieved, the respondents herein filed several representations to the department for consideration of his case for promotion, which were duly rejected. Challenging the non-consideration of his case for promotion, the respondent filed before the Central Administrative Tribunal, Guwahati, for a direction to the appellant to promote him to the grade A post, wherein his name figured in the extended list. Why the order did so and so, the tribunal dismissed the case. Paragraph 6, the writ petition, challenging the order of the tribunal, the respondent herein filed a petition being number so and so before the Guwahati High Court. The High Court by judgment dated allowed the petition and set aside the order passed by the tribunal and directed the appellant herein to issue appropriate order in favor of the respondent herein for promotion with all consequential benefits. Challenging the said order, the Union of India has filed this appeal by way of special writ petition. Now, your lordship will can see paragraph 11. Paragraph 11, your lordship will can see there is no dispute as to the fact that the office memorandum dated so and so Government of India, Public Grievance and Pensions, and New Delhi is applicable to the case on hand. Now, your lordship will kindly see the office memorandum dated. Next page, 14992. That paragraph 2 your lordship will get, and paragraph the Roman 3 your lordship will get.
Yes.
So same like Assam. This is all. This is only on the basis of that Janaki Raman's case, and paragraph 12. May I take your lordship through, my lord? It is not in dispute that the respondent had joined in the NF Railway on 4/11/77 and got promoted time and again while he was working as a Group B officer. His case was taken up for promotions to Group A. It is also not in dispute that in the meeting of the DPC conducted on so and so, the respondent names was considered and he was placed in the extended select list. It is further seen that up to so and so the date on which the respondent's batchmates were promoted to so and so, neither any criminal proceedings was initiated against him, nor any departmental inquiry was initiated, nor was any charge sheet served upon him, and nor was he placed under suspension, aggrieved by the non-consideration of his representation for promotion. The respondent filed over before the Central Administrative Tribunal and then thereafter High Court. Now, paragraph 14, my lord. 13, my lord. Agreed by the said decision of the tribunal, the respondent herein filed a petition before the High Court, wherein the said memorandum, particularly paragraph 2, was pressed into service. The High Court, taking note of the conditions prescribed in paragraph 2 and in the absence of any such conditions as on the relevant date, set aside the order of the tribunal and directed railways to consider the case of the respondent for promotion. As per para 2 of the said memorandum, paragraph 14, at the time of consideration of the government servants for promotion, the following details of the government service in consideration zone for promotion falling in the categories mentioned should be specifically brought to the notice of the DPC. Government, number 1, government servant is under suspension. Government servant has been served with a charge sheet and the disciplinary proceedings are pending. The government servant is facing prosecutions for criminal charge and the said proceedings are pending. As rightly observed by the High Court, if the above conditions are available, even one of them, then the DPC has to apply the seal cover process. In the case on hand, it is not in dispute that the relevant date when the respondents' batchmates were promoted. Admittedly, on that date, the respondent was not under suspension. No charge sheet was served upon him, nor was he facing any criminal prosecution. In such circumstances, in terms of para 2 referred to above, the recommendations of the DPC has to be honored, and there is no questions of applying seal cover process. Now, paragraph 15, my lord, High Court fully justified in issuing the directions. And 16, when it is kept under seal cover, Janaki Ram is discussed. May I read?
Yes.
In as much as we are concerned about the first question, the dictum laid down by this court relating to so and so. On the first question, there is as to when, for the purpose of the seal cover procedure, the disciplinary criminal proceedings can be said to have commenced. The full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceedings or a charge sheet in a criminal proceedings issued to the employee that it can be said that the departmental proceedings criminal prosecution is initiated against the employee. The seal cover procedure is to be resorted to only after charge memo charge sheet is issued. Now, paragraph 17 in subparagraph 17 there itself. In conclusion, I should be one should be read to mean that the promotion etc. cannot be withheld merely because some of the disciplinary or criminal proceedings are pending against the employee. To deny the said benefit, they must be at the relevant time pending at the stage when charge memo charge sheet has already been issued to the employee. After finding so, in the light of the fact that no charge sheet was served on the respondent employee when the DPC met to consider his promotion, yet the seal cover procedure was adopted. In such circumstances, this court has held that the tribunal has already directed the authorities to open the seal cover, and if the respondent was found fit for promotion by the DPC, to give him promotion from the date his immediate junior series so and so was promoted. We see no reason to interfere with this order. The appeal is therefore stands dismissed. Now, paragraph 22, my lord, contrary arguments advanced. Paragraph 22. The R.S. Sharma case which was presented, that was not accepted by parity. C2. One judgment, my lord, division bench of Karnataka High Court, just to point out similar circumstances. Paragraph 3, a perusal of the material and record will indicate that the petitioner is working as a village accountant with the respondent from 2005 onwards on the basis of a complaint criminal proceedings in so and so instituted against the petitioner. Subsequently, on 2012-2021, the departmental committee meeting was held to consider the candidate for promotions, including the petitioner in. However, the petitioner was denied promotions on the ground that the aforesaid criminal case in was pending against him. A charge sheet was filed subsequently on 1/2/2022 in the aforesaid criminal case after the said DPC meeting was held, wherein the petitioner was denied promotion. So also the request of the petitioner by way of representation dated so and so having been rejected by the respondent, impugned endorsement dated so and so, the petitioner approached the tribunal in the instant application which was contested by the respondent and dismissed by the tribunal which passed the impugned order which is assailed in the present case. Paragraph 4, my lord, Janakiram's Raman case has been discussed. That merely pendency of the criminal or departmental proceedings will not be sufficient for keeping the departmental promotion committee's recommendation in respect of the petitioner in a sealed cover. So ultimately, there is a matter of the judgment relief provided is respondents are paragraph 7, my lord. The respondents are directed to consider the petition applied for promotion to the post of so and so with all consequential benefit. So this is one another one, my lord. The meaning of this is in not necessarily. Meaning of this is government servants in respect of whom prosecutions for a criminal case, a criminal charge is pending. It means, my lord, giving prosecution sanction, it means there must be charge sheet. Then only prosecution sanction commence. Without charge sheet, my lord, prosecution sanction, it may result in FR also. Or similarly, my lord, here in case, my lord, only show cause notice was given. There is no charge sheet has been issued in respect of the departmental functions. That's all. And one just sentence I wanted to show. Well, a paragraph, ILR 2013, Delhi. Yeah. Division. Paragraph 10, last man. That your lordship will find it at 2575. Page 2575. Paragraph 10, last 14. Your lordship.
Just a moment.
Yeah.
Paragraph
10, last one. That your lordship will get it at page 2575.
yes.
We are therefore of the opinion that when the charge sheet is filed in the court of law, it should be treated that prosecution for a criminal charge against such person is pending. So prosecution pending means when charge sheet is filed.
Okay.
This is. Now they are saying is in view of these three, we have kept it in because prosecution sanction has been given. And the whole Janaki Raman's case will go in vain now. Deeply. And I pray, my lord, the DPC or lordship will give direction to provide relief by opening the seal cover, whatever is there, opening the seal cover and all, with all consequential.
Yes, Mr. Dhar.
Well, I don't have much to say, my lord, here. Only that, my lord, I will go by a affidavit that we have kept the thing in seal cover because they are the prosecution sanction. Here, the thing is that, my lord, that prosecution sanction is not under challenge in this petition, my lord. I have gone through the prayers, my lord. The
No, that can be only done in criminal proceeding, in a criminal application under 482. The writ petition can't be
My,
for that relief.
exactly, my lord. This is not under 482, my lord, not for quashing. Number one, my lord, and we have gone by our office memorandum, my lord. My lord has a copy of the office memorandum, my lord. So, my lord, office memorandum, para 2 and para 6. That is our case, my lord.
Yes,
Para 2, my lord.
yes.
At the time of consideration of the case of the government servant in the zone consideration for promotion falling under the following categories should be specifically brought to the notice of the Department Promotion Committee, Selection Committee, Appointing Authority, my lord. The three are, my lord. Number one, government servant under suspension, government servant in respect of whom charge sheet has been issued and the disciplinary proceeding are pending, and government servant in respect of whom prosecution of criminal charges is pending, my lord. So, my lord, he will basically fall in 3, my lord. Government servant in respect of whom prosecution of criminal charges is pending, my lord. And para 6, my lord. Why I said para 6, my lord?
What is the date of the DPC?
DPC date is, my lord,
It is in March 2020.
yes, 2020 March.
The notification for promotion was given on 17/4/20.
DPC in March 2020? 2020.
2020. And a notification where our batchmates were promoted, that is on 17/4/20, page 13.
13.
Seventeen or 13?
21.
So 17 for 20.
2020.
17 for.
Page 13
20.
of the writ petition, my lord.
Now, what is the date of that sanction for prosecution?
Prosecution sanction is, my lord,
21/11/19.
21/11/19. Prior to the, my lord, DPC.
Please give the date again. Prosecution sanction was?
My lord,
Date?
21/11/19.
21/11/19, my lord, 2019. Since that prosecution sanction is already, my lord, has been granted by the government, my lord. So we could not, my lord. And that is still in force, my lord, that prosecution sanction. The writ petitioner did not challenge it for quashing or. So, my lord, this para 6 of our office memorandum, my lord, we are relying on that.
But then the repetition has to be allowed. Because notwithstanding the prosecution sanction given on 21/11/2019,
DPC came later, my lord.
The prosecution against the petitioner,
my lord,
is in PRC 358 of 2022. Correct. 358 of 2022. Therefore, in all probability, the proceedings was instituted before the court in the year 2022. We don't know about the date when charge sheet was submitted.
Sanction was given in 19. And regarding charge sheet, my lord, I don't have information here, my lord. But my lord, once we have given a proceeding sanction, my lord, we have to go by the office memorandum that we have, my lord.
Okay, continue to. Two. J. Someone present classroom. Okay. Okay, reverse. Double. Get into control.
Solution. Oh, well, before that, because since I have item number 51, mile. Yes. So can it be on 21st mile? I was my line of friend also mile. Evaluation. I will not be available next week, mile. That's if possible. No, for the time being next week, mile. I don't know how to adjust. After 4th June, mile, that's whether it will be indefinite period or that is.
You doubted my words earlier. You remember?
That your lordship.
When I told you that you will not be here, you doubted my words. You said that you don't know.
May God my Lord secure that.
That would happen because I have some gray area for the antenna. Some bald areas I have in my house.
Let us see
Okay.
what happens. 21st.
Okay.
21st February.
Both sides are present on the prayer made by Mr. H.R. Chaudhary, Senior Counsel, assisted by Mr. A. Alam, Counsel for the petitioner, list on 21/5/2024.
All right.
Mr. Das, I requested my court to find out, we will not be able to locate. Well, I'll call for the charge sheet.
Let that is that subject to what your lordship be said. Charge sheet has not been filed as yet. No, charge sheet has been filed, charge sheet has not been
No,
filed.
if it is post the, if it is
Post.
later on,
Post.
then you succeed.
Then if your lordship knows, no, your lordship is convinced on that. PRC case was on a charge sheet filed on PRC case was on 23/3/22.
Where do you find that?
23/3/22. My client has informed. PRC case next date is 14/5/2024 for consideration of charge.
Okay.
Consideration of charge.
That is
No, because
post.
if the charge sheet is later on, then we have authorities in the Supreme Court to, which has determined
That is
matter.
very clear on the date of consideration of the DPC. There was no charge memo, there was no charge sheet. And if this charge memo and charge sheet is not there,
What is the date?
Now the PRC case next date is 14/5/24.
No, the date on which charge sheet is filed,
Charge sheet filed on PRC case 23/3/22.
23,
3/22. And the DPC was held on in March 2020. March 21.
that you have said March.
On the day when the DPC was held, there was no charge sheet, there is no charge. Even now, there is no charge. And they have said it is because of the prosecution.
Yes, okay, then let me get it, because when we'll be making an observation without the document in hand, if we make an
Yes,
observation, that would
definitely.
not be
No problem.
appropriate.
Only one case, our court case, I just wanted to give it another. We have given a copy. WPC judgment, I think division bench judgment, single bench judgment by Honorable Justice Suman Shyam in WPC 448/2023. Paragraph 13, 14. Paragraph 13, my last sentence, if I read. Therefore, there can be no doubt that the fact that on the date of holding of the DPC selection committee meeting, there was no departmental proceedings pending against the petition. Paragraph 14, in the case of so and so, the Supreme Court has categorically held that it is only when a charge memo in a departmental proceedings or a charge sheet in a criminal prosecution is issued to an employee, then it can be said that the departmental proceedings of criminal prosecution has been initiated against the employee. The seal covered procedure is to be resorted to only after the charge memo, charge sheet is issued. The pendency of any preliminary investigation prior to that stage will not be sufficient to enamel the authorities to adopt the seal cover. So accordingly, it was given. And in this Anil Sarkar's case, your lordship has already seen, there were as many as 5 charge memo, 11 FIRs. But court said since there is no charge sheet and no charge memos, so therefore things are there.
DPC date 5/3/2022.
DPC date,
Departmental Promotion Committee.
oh, my lord, the departmental promotion committee date is, exact date is, my lord, 5/3/2022. 21. Not March, but the date is 5th March. So on that date, nothing is there, no charge sheet, no charge memo. Your paisa.
Okay, we've got to check it out with pass orders.
Justice Suman Sam's order, I have given copy, printed.
Yes. Get the records verified and pass orders. Yes, item 2.
Instruction received, Lordship. It has been reviewed, Lordship. Suspension order has been reviewed, Lordship. For another 3 months. On 4th May, Lordship. And DP was also spending, Lordship.
That is again,
Take instructions and then
and that's,
Furnished, Lordship.
that is also again without any assigning any reason, Lordship.
No, Lordship, DP is pending, Lordship, till completion of this DP, or Lordship, after 3 months is over, Lordship.
My sole question is that that order has been passed, Lordship, without assigning any reason, Lordship. There must be a, Lordship, reason order. And today is 10. If the order is passed on 4th of May, they could have communicated it. That was also not done.
pardon me.
And of this order, it has to be passed on, issued on 4th of May.
Yes.
And today is 10. That order has not been communicated to me. My sole ground in the reputation is that that order is without any
Not a
reason.
correct statement, Lordship. It
There
was a
should be
past,
a-
Lordship. So cause notice was issued, Lordship.
Everything is okay, but order is without assigning any reason. There should be a valid reason for continuation of the suspension. That has clearly violated the division bench order.
He challenged this order, Lordship. On 4th May, Lordship.
No, once he's challenging the first part that the order is non-speaking, the second order, will, even if it is not challenged,
Lordship, suspension is order is reviewed, Lordship, as per our instruction, Lordship.
no, that's
And
okay, but
Department
what is the
proceeding
law?
pending,
What
Lordship,
is
till
Ajit-
completion of the DP, Lordship.
No, what does Ajit Chaudhary say? Is it a requirement to pass a speaking order or to just say
No,
this is enough?
It's a reasonable order, Lordship.
What is the reason?
Shows that.
No, not a DP is pending,
No,
Lordship.
that's okay. You see, Mr. Khan is trying to say that even this order has to be a speaking order.
May I should submit this order as well? But in pursuance to the division bench order, there are some other cases lawsuit has
My
been
lord,
disposed of.
if you go by the ratio laid down in Ajay Chaudhary, my lord,
Yes,
the last paragraph, my lord,
in Ajay Chaudhary,
Ajay Kumar Chaudhary, my lord.
yes.
So far as the facts of the present case are concerned, the appellant has now been served with charge sheet, and therefore this direction may not be applicable on him. However, the appellant is so advised, he may challenge his continuation suspension in any manner known. So, my lord, basically when charge sheet is filed, my lord, he's given show cause notice, charge sheet filed, my lord. Now DP is continuing, my lord. He can only, my lord, now challenge his suspension that there is continuance, my lord. But he cannot, my lord, avail just that it's not reasoned order, my lord. Once charge sheet is filed, my lord.
That has also been considered lordship in the division.
Yes, that's all. Let him complete. He'll come back to you.
প্রশান্ত দত্ত প্রশান্ত দত্ত এডিশন আসবে
Okay. So you're saying that after charge sheet is filed, this order is sufficient?
Madam.
Yes, Mr. Khan.
It has been reviewed, my lord. We have reviewed the order, my lord.
My lord, in Ajay Kumar Chaudhary case lordship, that has already been considered in the division bench order. And paragraph 21 in your lordship kindly come to Ajay Chaudhary's case. In that case also lordship saying, may I read lordship, paragraph 21. We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period, the memorandum of charge sheet is not served on the delinquent officer employed. If the memorandum of charges is charge sheet is served, a reason order must be passed for the extension of the suspension. Here, lordship, this is also clear that they must pass the reason order.
Yes. My
Even
lord,
after submitting the charge sheet.
my lord will.
Yes.
So no reason order has been passed, lordship. Only mechanical order that has been passed. So this order, lordship, may not sustain.
After para 21, my lord, para 22, my lord. That is what, my lord, the irony of Ajay Chaudhary judgment is that, my lord, so many people got, my lord, benefit out of this order, but Ajay Chaudhary got nothing, my lord, of this, my lord, from this order. That is what, my lord, Supreme Court has held, my lord. Para 22.
What are the dates here?
My lord, suspension is initial suspension was made on 7/11/2023, lordship, page 18.
Yes.
And I release on bail, lordship, 14/12/23.
No, bail is not required for that.
My lord.
Yes.
And they had filed representation 3/1/2024. After that, lordship, that input order was passed. And show cause notice, that is page 23, lordship.
Yes, what is the show cause notice?
Page 23.
Dated?
Lordship. Dated 27/12/2023.
Yes.
My application, lordship, page 24.
And then your suspension order,
Suspension order, lordship, page 18, initial suspension order,
page 18.
18/1/8.
Yes.
Page 18. 7/11/23.
Second extension,
That is page 26.
26.
26. That is under challenge. I 2020.
Okay. Let me examine in pass orders. I'll release it today.
Well, item 3.
Item 3.
Just one. Citation to. I'm keeping your book here. Take it on Monday from the court master. Sticker log. Yes.
No, item 3, lots of instruction received, lots of, it seems to be a reasonable order may pass, lots of. Kindly see the instructions, lots. Kindly see the lots of bottom portion of this instruction, lots of para, lots of 5, lots of. May I read lots of.
You file an affidavit, then is
Lots.
this. You do it within 10 days?
Lordship,
You do it within 10 days?
10 days, Lordship.
Mr. M. Khan, then counsel for the petitioner. Mr. E. Chakravarti, learned government advocate, appearing for all the respondents.
No, Lordship, no, Lordship. I'm a 2 and 3, Lordship, I'm
Okay,
appearing.
2 and 3. 2 and 3. So, submits that he has received instructions and would be filing affidavit in opposition within 10 days. So, Mr. G. Henry Leonard, signing counsel for the Revenue Department. Comma for respondent number 1 is present. Next, madam. In view of the nature of grievance raised in the present writ petition. Comma. Issue notice returnable on, give a date after 10 days. Returnable on so and so.
Lordship, after the counting, Lordship.
No.
After the counting, Lordship. On,
Counting,
Lordship.
no, counting will be
Lordship,
sometime in June.
Some 4th June, Lordship.
Huh. No, we can't wait for that because once he's saying that there is a statutory.
Lordship. May, Lordship, May 24th, Lordship. 24th of May, Lordship.
24th.
Lordship.
Okay.
24th party, sir.
Okay, determined 24/5/2024. Requisite extra copies of the writ petition to served on the learned State and Department Council within 2 days. List on 24/5/2024.
Omelette. Omelette.
Fourteen.
As your lordship was dealing up with all bail matters and others regarding suspension and criminal, just now I saw in my live law that Arvind Kejriwal has been given bail, interim bail, up to June 1st. But one thing I didn't understand, my lord, in that case, there was no bail application. But the summon of by the ED was under challenge, as it was declared illegal, like a 482 quashing. And in that, interim bail has been given.
Lordship, I apologize for interruption. Lordship, my senior is on legs in court 12. The matter may be taken up after some time.
Okay.
Let me start, Malad, in the meantime. Let him come. I will
Let
start.
him come, let him come. You will not understand the.
Item 17.
Please, your lordship.
I think this matter has been, there is a decision of this court in the matter. Who's for health?
This is regarding lordship appointment of staff nurse lordship. Marks for experience was not given to
But
the
I think,
petitioner.
I think I have, this, the issue has been laid to rest. This is health,
Health lordship.
SC health, give us a scroll, SC health. Just wait for some time. Yes, Mr. Gogoi. Mr. Gogoi, this issue has been decided by this court. That experience for the staff nurse, the AHM should be given the due credit.
No, here, so far as the case is concerned, my lord, the petitioner did not upload the, my lord, experience certificate along with the document. So while verifying the documents, that marks was not allowed.
While uploading, it was not uploaded.
Not uploaded. That's the issue.
This is the application.
Yes, my lord. In
Yes.
fact, my lord, his plea, petitioner's plea is that, my lord, that option is not there. But like, I would like to point out to one page, my lord. Page, lordship will see, my lord, page 44. This is a notice dated 1/9/2021.
44.
Yes. This is the notice whereby the candidates were directed to appear for, my lord, document verification and skill test. Lordship will see in page 46, at the end of the list. Important. All the above candidates are directed to upload scanned copies of their documents at the link available at the official website of Director of Health Services Assam. Now, my lord, for the second time, they were supposed to upload. Here, my lord, the petitioner ought to have, my lord, uploaded the scanned copy of her experience certificate in order to, my lord, have that marks of 20, which she is claiming now.
I have uploaded that lordship.
Where is that?
Lordship, may kindly take my additional affidavit, page number 61.
61.
Yes, lordship. Page 61, lordship. Page 61.
Yes.
And lordship, this is lordship after publication of the result in the written test, lordship. I qualified in the written test. Thereafter, lordship, I have uploaded this on 10/9/2021.
Where do I get the date?
Lordship, at the bottom, lordship.
10/9, yes.
10/9, lordship. Lordship, may kindly come to the last 10 rows, lordship. Total year of experience.
Yes.
5 years, 6 months, 4 days.
Yes.
Last experience designation held, staff nurse NHN. Document uploaded status. Now, lordship, these are the documents which were allowed to be uploaded. Permanent resident of Assam, document uploaded successfully. Category, document uploaded successfully. HSLC, document uploaded successfully. HSSLC, document uploaded successfully. Degree, same. Assam nurse, midwife, so-and-so, document uploaded successfully. Employment exchange registration, document uploaded successfully. So, lordship, these were the documents which were allowed to be uploaded, and I have uploaded all the documents. There was no provision to upload the experience certificate, my lord. Even, lordship, nobody has uploaded this, lordship, as because that provision was not there. We cannot upload, lordship, anything less or anything more, lordship. This was a totally online process. Now, lordship, may kindly come to page number 51, lordship, of my writ petition. Page 51, my lord.
Yes.
This is the information I received under RTI. Question number 6. Marks obtained, written 51 out of 100, lordship. Skill test 18, that is out of 25. Experience, no experience certificate serving under NHN. So Lordship, at the time of submission of my application and as well as Lordship, at the time of submission of uploading the documents, Lordship, the only provisions which were there, Lordship, were to upload those documents. Even Lordship may kindly come to the advertisement for a moment, Lordship. Page number 37.
Yes.
My lord, may kindly come to page number 38.
Yes.
Interested candidates, clause number 3, interested candidates shall have to fill up the online application form available at the official website of Directorate of Health Service Assam, so and so. The following documents in original will have to be produced at the time of document verification, and photocopies of all certificates, etc. are to be submitted. A, 2 copies of recent passport size photograph. B, birth certificate. C, all past certificate from boards, universities. D, caste certificate where applicable. E, permanent residency certificate. F, person with disability certificate. G, employment exchange certificate. H, nursing registration certificate. I, pharmacy registration certificate. J, economically weaker section, EWS. Now, Lordship may kindly come to clause 7. Weightage for service under NHM. Clause 7, Lordship.
Page?
Same page, Lordship, 38.
Yes.
Clause 7. Weightage for service under NHM. Many contractual employees are working under NHM as nurses, paramedics, etc. They may be given weightage of 2 marks per year of service completed under NHM, subject to maximum 20 marks so that they can be given suitable and justified preferences. Lordship may kindly come to page number 14, my initial application.
40.
40, Lordship.
Yes.
Last 1, 2, 3, 4. Last 8 lines, Lordship, I am reading. Total year of experience. It was, dear Lordship, total year of experience.
There's something wrong in this document. This is not your original application. It may be a downloaded copy.
Yes, well, downloaded copy and this, my lord, the copy that has been annexed in the reply and the one which has been annexed in the writ petition is one and the same.
But the date is different.
My lord, probably
But
one
the date is
document-
different.
Yes, only date is different. That probably is the downloaded or uploaded date, my lord, either way. But page 66 of the affidavit that we have filed, the running page number 66. Probably, my lord, this particular notice of 1/4/2021. Para 7, Lordship may kindly see. The deponent begs to state that due to post-COVID-19 pandemic, the skill test for selection to the post of staff nurse was conducted through online mode. In this connection, a notice was issued by number so and so, dated, my lord, 1/4/2021. Subsequently, in the said notice, it was directed to all concerned candidates to upload scanned copies of documents in the given website of the Director of
No,
Health
but it
Services.
can't be a hidden criteria. If you don't have the slot for
That's why, my
uploading
lord,
of that
what
document.
was there in this particular, my lord, 1/4/2021. My lord, let me place it on Wednesday, my lord, 1/4/2021. This notice, notice is not a part of the writ petition as well as the affidavit.
And Lordship, apart from that, Lordship, if my learned friend can show that, Lordship, there was provision to upload the certificate, Lordship, then I don't have any case.
That's why,
Even,
my lord.
Lordship, even Lordship, if any other candidate have submitted, if they have submitted the experience certificate.
No,
Lordship.
so even if other is submitted or not, it is your case you are scrutinizing.
Yes.
If you don't know about uploading, maybe you get the benefit.
My lord.
Others may have uploaded it.
Nobody has uploaded it, Lordship. There was no provision, Lordship. Lordship, this was an online process, Lordship. I cannot upload my experience. Even, Lordship, suppose 3 documents are to be uploaded. I have not uploaded one, Lordship. Then, Lordship, I cannot submit it. The computer will not accept it, Lordship. I have to fill up each and every lines, Lordship.
Oh, that's okay. You get a benefit out of that.
Yes.
Even if others
Indirectly,
do or
that
not,
will help the petition.
even if others do or do not do,
Yes.
doesn't matter to you if they can't show that it was there was a provision for uploading it.
Yes, Lordship.
Okay.
And in the Lordship may indicate in the order, my lord, whether there is any vacancy as of now, because my lord, this is a selection of 2000.
No, because if it is even if it is not there, you can have to create supernumerary posting.
Maybe, my lord, there may be vacancies, my lord. I can have the inspection on that point too. And whether, my lord, otherwise, if say, my lord, this 5 years she has, whatever she has annexed in the repetition, considering that whether she will come under the zone of consideration, otherwise she would have come under the zone of consideration. That also I can have the inspection. Because last candidate who has been selected under her category, if she now is her marks is more than that particular candidate, then of course she would have been selected.
Okay. But Mr. M. Ahmed, counsel for the petitioner, Mr. B. Goel and his standing counsel for the
Health department.
Health Department has referred to the affidavit in opposition filed by respondent number 2 and submits that he may be given time to produce a copy of notice dated 1/4/2021, which is referred to in paragraph 7 thereof. Next paragraph. The learned standing counsel for the Health Department will also obtain instructions as to whether in connection with recruitment drive for filling of the post of staff nurse initiated by advertisement dated 5/9/2020, whether there is any vacancy. Post of, we shall also inform, obtain instructions. You just say one, that is one. That's number 2. What was the experience of the staff nurse selected under the said recruitment drive as a staff nurse of National Health Mission? What is the total experience of the nurse, of the last nurse selected, the last staff nurse selected under the having the experience as a staff nurse of National Health Mission? Language is okay?
Well,
huh? Okay.
And Lordship, whether there was any provision to upload the experience certificate?
Yes.
No, because that will not put. Because if it is not there, supposing tomorrow they give a certificate that it was not there, then it goes against you.
Not true. The experience is my lord nurse under my lord NSM. That is very special.
Experience as a nurse
Under
NHM. Okay.
I'm still working, Lordship. I'm still working, Lordship, under NHM.
Okay, NHM. Okay.
I can see as a
My lord, regarding the vacancy part, my lord.
Huh? Okay.
vacancy would be there, Lordship. There will be dedicated to the staff nurse in 419 club.
Next one is this one. 15/5/2024.
Well, let it be 17 months. 70.
Okay,
17.
17. Yes.
Obliged, sir.
Highly obliged.
Eighteen to 20.
In this, Mr. Lanet Council, K.M. Sudhuri Arbuda matter, he is late in court number 12. Maybe taken after some time, my
So
lordship.
maybe a date will be fixed, lordship. It's already 3 o'clock. Almost. And it takes some time, I guess.
Next person.
So it's a date, both of you.
Anytime, date takwa.
No?
Date takwa. Next week, lordship.
Next week, any date, I guess.
Agree to both of you, your senior council are there, you address.
Lordship, 16th? 16th is fine. 16th?
16th, no, there's a division bench.
Lordship, 17th is a Friday. 17th?
17th.
My lordship, writ petition 2961 is there is an interim order, may something.
Interim will continue.
Both sides are represented. Therefore, adjournment is made on behalf of Mr. Ken Chaudhary, senior counsel. For the petitioner as he is on legs. This is M. Sarikal and the senior counsel for the NRL. Along with her instructing counsel is present. Next para as agreed to by both sides, list on. When?
17th?
17, 5/2024.
Right.
Interim order passed in this and extended to the next date of the same. Interim order was in which case?
2961, no?
Writ petition 2961 of 2022.
Stands extended to the next date.
24.
Petitioner is a retired.
Where is the document showing that he has been furnished with a remark in the ACR?
Page 23, 28 is the interim order.
28.
Yes, ma'am.
No, I'm asking Mr. Mr. Bora.
Yes, my lord.
Where is the service of the remarks in the ACR to the petitioner?
It is not there, my lord.
No, he was not communicated, my lord. Never
That's why
communicated.
we are asking you.
It's
Not there. It has to be set aside. It has to be considered. With effect from the date when his junior got promotion.
Yes, my lord. No, sir.
Heard. Mr. N. Sharma and counsel for the petitioner. Also heard Mr. D.P. Bora and standing counsel for the health department. Representing all the respondents. Next paragraph. the decision of the government in the Health and Family Welfare Department by the interim order dated 12/1/2023 thereby refusing to consider retrospective promotion of the petitioner for promotion to the next higher rank of superintendent is under challenge in this writ petition filed under Article 226 of the Constitution of India. On the ground. Sorry, this was a challenge. Visible responsive to is that assigned the next paragraph. The case of the petitioner, in brief, is that that he entered into service as the lower division assistant in the office of the Director of Medical Education from Assam in the year 1981, and he was promoted to the post of Upper Division Assistant on 21/9/2004. Stop. Selection Board meeting was held on 1/12/2015 for considering promotion of the eligible upper division assistants to the post of superintendent, correct?
Yes.
Post of, as there was some delay in the conclusion of the selection process, the petitioner had approached this court by filing WPC 2339 of 2016 yes. However, this we can't strike that off. Meeting was held on 1/20. So, however, the selection board did not consider the case of the petitioner on the ground that there were two contradictory remarks in the ACR as well as in the certificate issued by the administrative officer in respect of the petitioner. Post of. Accordingly, the agreed petitioner approached this court by filing WPC 2339 of 2016. And this could be order dated 7/4/2016. Took into consideration that the selection board had considered the ACR for last 5 years for promotion of the petitioner. First of comma, and that the minutes of the selection board meeting did not specify what contradictory remarks were made in the ACRs and for which years. First of, this court had also issued a direction to the Director of Medical Education Assam to give his clarification, which had not come for last 4 years in the proceedings of the said petition. And on consideration that the superannuation of the petitioner was due in the month of November 2016, the said WBC 2339 of 2016 was disposed of by order dated 7/4/2016. By directing the Director of Medical Education Assam to furnish the necessary clarification sought for by the selection board in its meeting held on 1/12/2015 within a period of 30 days from the date of receipt of certified copy of the order. First, it was provided that the clarification should be furnished to the Secretary to the Government of Assam, Health and Family Welfare within bracket A bracket close department, who shall thereafter ensure constitution of review selection board to consider the case of the petitioner for promotion. First one. Accordingly, a review selection committee meeting was held on 21/9/2016. And the said committee, citizens, and the review selection board had recommended, in its meeting held on 21/9/2016, had recommended the name of the petitioner for promotion to the rank of superintendent in the office of the Director of Health Services, Assam. So, however, as the petitioner was not given promotion, the benefit of promotion, the petitioner had approached this court again by filing WBC 3323 of 2017. And this court, by order dated 28/2/2019, disposed of the petition with a direction to the respondent authorities to reconvene the DPC for consideration of promotion of the petitioner to the higher post of superintendent by taking into consideration the ACRs for the last 5 years as per rules. Full stop. It was further directed that if there be any uncommunicated remarks in the ACRs, the same cannot be acted upon by the DPC. And the DPC was directed to proceed to examine the case of the petitioner on the basis of only such remarks which were communicated to the petitioner, but not such adverse remarks which were not communicated to the petitioner. Full stop. Taking note of the fact that the petitioner had retired from service on 30/11/2016, it was directed that the exercise of holding a review DPC shall be undertaken within a period of 3 months. Full stop. Next one, pursuant to the said order of this court, of review DPC was held on 4/11/2022. Only after the proceedings of contempt con case C number 700/2019 was instituted. Full stop. 8 numbers of ACRs of the petitioner was produced for examination by the DPC. And the DPC noticed that 5 numbers of ACRs pertaining to the year 1/4/2008 to 31/3/2009 due to (31/3/2013) One four 2028 to 31/3/2013. We are having serious and adverse remarks against the petitioner. And there was also a reference to the criminal case registered as dispute PS case number. Registered at Dispute Police Station under section 420/406/506 IPC. And that the DPC also noticed that the adverse ACRs of the petitioner was written, we were all written on 9/9/2013 and were not communicated to the petitioner. And the ACRs for other 2 years with effect from 1/4/2013 to 31/3/2015 were not found complete. And therefore, the DPC refused to consider the promotion of the petitioner to the rank of superintendent based on only ACR for 1 year from 1/4/2015 to 31/8/2016. comma, before his retirement on 30/9/2016. Full stop. Accordingly, the appropriate authority in the Health and Family Welfare Department, comma, Government of Assam, had decided that the retrospective promotion to the petitioner for the next higher post of superintendent could not be considered. And this is said in the full stop. Accordingly, the Principal Secretary to the Government of Assam, Health and Family Welfare Department, had issued the speaking order dated 12/1/2023, stating that the retrospective petition, promotion of the petitioner to the next higher post of superintendent could not be considered. First, the per contract, the respondent number 2, by filing the affidavit in opposition, reiterated that the ACRs for the 5 ACRs for the year 2008-2009, 2009-2010, 2010-2011, 2011-12, and 2012-13, though having serious and adverse remarks against the petitioner, were found not to be communicated to the petitioner, and that all those ACRs were written on 9/9/2013, and accordingly, the ACRs of the petitioner for the said period were treated as no ACR. And it was also posited that the ACR of the petitioner for the period from 2013-14 and 14-15, 2014-15 were not complete. First off, hence it is submitted that the anonymous decision of the ACA of the DPC was not to consider the case of the petitioner for promotion. Next paragraph. It is seen that the respondent authorities have already taken a decision that ACRs for the 5-year period from 2008 to 2013 were not communicated to the petitioner, for which those ACRs were treated as no ACR, and the adverse remarks against the petitioner was not considered. The stand of the respondents is that, respondent number 2 is that the ACRs for the period 2013-15 were not complete. So definitely, comma, in the absence of any specific statement made in the affidavit in opposition filed by respondent number 2, it cannot be presumed that the petitioner has any hand in the incomplete his incomplete ACRs. This is not the case of the respondent number 2, that the ACR of the petitioner was kept in his custody. Therefore, comma, in this case, the petitioner has been denied promotion for none of his fault. Instead of drawing up proceedings under those persons who were in charge of writing ACRs, being the reporting and the reviewing authorities, the respondent in the health and family welfare department have penalized the petitioner for not for his incomplete ACR, over which he has no control. There is nothing on record to show that even the incomplete ACR was brought to his notice. Stop. Therefore, the court has no hesitation in setting aside and quashing of the impugned order number HLA 240141 of the 588 dated 12/1/2023, issued by the Principal Secretary to the Government of Assam from our Health and Family Welfare Department. Full stop. It is noted that next part, it is noted that every time an ACR of the petitioner is every time the consideration of the promotion of the petitioner is taken up and promotion is denied to him, this court by orders passed in WPC uh, 2339 of 2016, as well as 3323 of 2017, and directed the review DPC to be taken up in respect of the to reconsider the promotion of the petitioner. First of on all these on the said 2 occasions, in the second case, where is the recommendation of the DPC? Second time, sorry, third DPC, where is that? What is the finding?
That is at page 34, my lord. My note sheet here.
Recommendation page in the first review DPC, which was held on 21/9/2016. My recommendation was made for promotion of the petitioner to the rank of superintendent. But the petitioner was not given the benefit of promotion. Just after the after the order of the court passed on 28/2019 in WBC 3323 of 2017, second review of DPC was held in respect of the petitioner. And as per the minutes stated 4/11/2022, the DPC could not take a decision on the promotion of the petitioner based on 1 year ACR. Therefore, the court is therefore, the court is inclined to citizen and quash the proceedings of the DPC meeting held on 4/11/2022 for reconsidering the promotion of the petitioner to the rank of superintendent, as well as the consequential order number HLA 240141 of the 588 dated 12/1/2023, issued by the Principal Secretary to the Government of Assam, Health and Family Welfare Department. Next, taking note of the fact that this court had already held that the uncommunicated ACRs for the year 2008 to 2013 could not be considered. They cannot be considered for the adverse entries not being communicated to the petitioner. And the two ACRs for the period 1/4/2013 to 31/3/2015 were incomplete. Therefore, the respondent authorities, including the Departmental Promotion Committee, within bracket, with whatever name called, bracket closed, has to consider the case of the petitioner for promotion only on the basis of the only available ACR for the period from 1/4/2015 to 31/8/2016. Full stop. The respondents cannot shirk of their responsibility of considering the candidature of the petitioner for promotion based on the set sole ACR from 1/4/2015 to 31/8/2016. Accordingly, the Principal Secretary to the Government of Assam, Health and Family Welfare Department is directed to convene a review departmental promotion committee within an outer period of 60 days from the date of service of certified copy of this order for considering the candidature of the petitioner for promotion to the rank of superintendent on the basis of the only ACR available for consideration, i.e. for the period 1 what is the date? 1/4/2015 to 31/8/2016. According to the Principal Secretary of the Government of Assam, Health and Family Welfare Department shall also issue a direction to the DPC to consider the candidature of the petitioner based on the said sole available ACR. Alone. Without being influenced by any uncommunicated remarks that may be found available in any other ACR of the petitioner. First of the DPC shall the review DPC shall pass an appropriate recommendation within a period of 30 days from the date of its from its constitution. Yes. Full stop. Next part, it is needless to say that as the petitioner has already superannuated, the Principal Secretary to the Government of Assam, Health and Family Welfare Department shall ensure that whatever recommendation or orders are made will be communicated to the petitioner in his email address to be provided, email address or WhatsApp mobile number to be provided by the petitioner. Petitioner shall produce a certified copy of this order before the said authority.
My lord, in the event of recommendation, notional benefit should be paid from that date when that
Always happen. We don't have to say that.
Yes, madam.
that observation. Otherwise,
It's not required. If they consider you for that period,
Obliged, madam.
Time being item 14.
it is needless to say that if the petitioner is found entitled to any consequential benefit, same shall be extended to him.
Obliged.
Yes. one moment. Yes, item 14.
May it please, your lordship.
Yes.
He was here again, he went out.
Who?
The PG9, he was here, man.
Can you make notes? Let him start. Yes.
My lord, the case of the petitioner is as such, my lord. The petitioner was appointed as an electrician under the PWD engineering service rules, my lord, in 1996. Thereafter, she took a study
But
leave.
electrician cannot be promoted to the
My lord,
assistant engineer.
My lord, I'm placing, my lord, how the case has been, my lord. Electrician, then she completed her bachelor's degree of engineering after taking study leave. My lord, now she has is before this honorable court on 3 counts, my lord. First of all, my lord, when the writ petition was filed, there was a draft service rule
because electricians, they don't have a service rule. They, on a draft service rule, there was a provision which said that a man or a lady working for a considerable period of such years will be considered for the post of junior engineer, where from the service rule started. The next next count was there, that there are few persons who were working as in the ex-cadre post as section assistant or some other post, and they were given the scope of being promoted to the post of junior engineer, thereafter assistant engineer and executive engineer, and they have retired. There were 3 examples were given by the petitioner. My lord, then the third point was there, the count for which the petition is before your lordship is this, that a post, this electrician post has been kept for such a considerable period of time. Neither it has been abolished, neither has been taken away. And they are continuing for more than 20 years. Either they should have been encadred or their post should have been abolished. That is the Supreme Court's direction is given, my lord. In a case of 2000, there was a statement there where, my lord, a post for a considerable period been kept. Neither it was abolished, neither it was encadred. For that reason, my lord, there was a direction from the court that I encadred them and then give the promotion. That was the directions. On the first count, my lord, because of the service rule, my lord, there was a provision, your lordship may take out at page, in the writ petition, page 78.
It is a part of what?
Writ petition.
No, it is a part of what?
It is a part of the draft service rule.
Draft service rules.
Draft service rule. I want to place it because the first count was that, but not on the basis of this, I got an interim order. And because there were 3 posts lying and 1 post was kept reserved for me.
Yes.
Clause number 7. Promotion to the cadre of junior engineer mechanical may be made from head mechanic such and such, such and such and such. I skip over. Then, my lord, from after above, promotion to the cadre of junior engineer electrical may likewise be made from the cadre of head electrician if he possesses the diploma in electrical engineering from a recognized institution having AICT approval and rendered 15 years of continuous service in the cadre of mentioned above. Promotion to the cadre of junior engineer civil may likewise be made. So it could have been made by a draft service rule. But my lord, here in this case, my lord, they filed an affidavit and stated that the draft service rule has become obsolete and they have redundant. So my lord, that was the on the first count, my lord, they have stated that the draft service rule is not applicable. Next, my lord, the next count is this, my lord, that I made a categorical statement in my rejoinder stating therein that there were 3 persons who were working in page 99, continuous page 99, madam. In my rejoinder, where I have stated, my lord, page 99, that the deponent states there are instances in the department, White C. Bhavesh Chandra Deka, Sudhanshu Sen Sharma, and Motin Chaudhary were promoted to the rank of executive engineer, assistant executive engineer, respectively, from the post of electrician grade 4.
You're reading where?
Page 99.
99.
Continuous page 99. Para 6. Para 6, your lordship has got it. that at the deponent state that the instances department such and such person were promoted.
This is your affidavit.
My affidavit, rejoined.
Then we'll have to adjourn the matter today.
My lord, why, my lord?
This page 99. This. You see page 99.
Well, it has not been filled up.
Adjourn it. It permit you to
Fill up.
not fill up. That can be done. You have to file a fresh affidavit.
I have to file a fresh affidavit.
Well, affidavit we can't permit you to.
Because on
Correct.
this, the affidavit in reply has also come.
No, that's okay. We'll take that into consideration, but this has to be rectified.
Can I file a rectification application?
No, because there are judgments which says that affidavit can't be rectified, but you can supplement it. We'll permit you to supplement it.
I will supplement it by an
Another affidavit.
affidavit.
Do it. It's an act. Technically, it is
Not.
we'll have to overlook. In case of health, that nurse, this will go in that way. No? No, this file. At the outset, Mr. P.K. Rajodi, when counsel for the petitioner, submits that there are some inadvertent error, that some error has crept in the rejoinder affidavit filed by the petitioner on 19/6/2023. So he permits, he prays foreign is allowed to supplant this affidavit by a fresh one. Next one. Mr. P. Nayak, Leonard Standing Counsel for the PWD. For all the respondents?
Yes.
For all the respondents is present. By when? Should I list it?
Next week.
Next week. We list it on Friday then?
Friday.
List on 17/5/2024.
Item 25.
Yes.
My lord, the issue involved here is in a very narrow campus, my lord. Your lordship will kindly come to page 42.
42.
Yes, my lord. Of the writ petition.
Just a moment, Mr. Mohammed.
Yes, ma'am.
There's something wrong here. No, there's something wrong here.
Hello.
This notice was, the government advocate could not have accepted notice for 6 to 12. Therefore, no notice was issued there. The court has recorded that the government advocate has accepted notice for all. They could not have accepted notice for 5 to.
1 to 5 they can accept it.
No, but then notice to others are not there. You see, we can't pass adverse orders against them without service of notice.
Let me issue notice.
Because what has happened here, this court has recorded that the government advocate accepts notice for all. So that was on a wrong premise. Notice is not issued.
6, 7, 8, 9, 10, 11, 12.
6 to 13.
Yes, ma'am.
6 to 12.
12.
Mr. K. Mohammed Lanet, counsel for the petitioner. There's only one petitioner.
Yes, ma'am. 3 petitioners.
Petitioners have submitted that although notice was issued, notice of motion was issued by order dated 22/3/2023. No direction was issued for taking steps on the private respondent numbers 6 to 12. So accordingly, the petitioners are directed to take steps for service of notice on the respondent numbers 6 to 12 by registered post with AD. Editors takes steps within 2 days, within 3 days.
Yes.
For service of notice on the respondent numbers and so. First off, the notice is made returnable on, give a date after 5 weeks. First off. Next paragraph. The learned counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal track report prior to the next date of registering. Next paragraph. It is reiterated that in terms of order dated 22/3/2023, it is again reiterated that appointment, if any, made to the post of Anganwadi worker and or Anganwadi helper pursuant to advertisement notice dated 5/12/2022 in respect of 204 Daya Basana, DAYA BASANA AWC, 17 number Balasar BALESWAR dash Roman 2 and 36 number Chaikut CHAYKUT AWC shall be subject to further orders that may be passed in this case. Next paragraph. Mr. A. Chakravarti, a government advocate for respondent numbers 1 to 5 is present. But you are also required to file your response.
Yes, my lord.
The issue is whether the married daughters can
Apply.
participate from which village.
Because apparently, my lord, there is a gazette notification.
No, it's okay, but they'll have to take a stand.
Yes.
2106.
Deeply obliged.
Item 31.
May I please, your lordship? Lordship, in this case, instruction received, lordship. 3 weeks time may be given to file affidavit, lordship.
Lordship, these instructions have been received by respondent number 3. However, till date, no one has appeared on behalf of respondent number 4. In fact, your lordship, in order number, the order dated 29th of November also, it has been reflected that service is complete. order dated 29th of January also, Your Lordship, but no one has appeared till date on behalf of the liquidator of the Hindustan paper.
I don't know whether there will be a necessary party or not. Liquidator, does it exist now?
Lordship, in 2023, they were in touch in the sense that
No, I
they were
don't know.
sending representation to
It's
Lordship.
something you will have to take a call. I'm personally not aware of it. And liquidator, this address should not be correct address. You know why?
The old
Come to page 41. 40.
Yes, Your Lordship. This was the address at that point of time, Your Lordship.
Because
but-
here it refers to the Karnataka High Court and says it was, the address is attached to those that. We don't know who is the liquidator now.
Lordship, I'll check on this. Otherwise, as on till April 2023, the official liquidator was Kuldeep Verma, who was
No, I
responding to
understand, but
the.
you have given an address. We are just trying to show that this address, whether it is right or wrong, we don't know. You are for the same petitioner who is appearing at, whose name appears at page 40. You can't have two addresses.
Lordship, I'll check on this.
Correct. The second reason is that you read order 6, rule 14A, sub rule 5. Then you will come to know 5 and 6. Then you will come to know why I'm saying that. Both sides are represented. Mr.
DJ Boro Lordship, on behalf of Jackie Goswami, Standing Counsel AIDC. Lordship, our name has not been shown in the post.
DJ Boro, counsel appearing on behalf of Mr. J.K. Goswami, standing counsel for respondent number
Respondent number 3, Lordship,
3,
AIDC.
for AIDC Limited. Come on. Praise foreign is granted. How much time?
3 weeks time, Lordship.
3 weeks to time, with 3 weeks time to file affidavit in opposition in the matter. You're for
Respondent 1 and 2, Lordship, for Industries and Commerce Department.
Mr.
N. Kalita on behalf of A.
and
Kalita.
Kalita, Learned Counsel appearing on behalf of Mr.
A. Kalita.
A. Kalita, standing counsel for Industries Department, representing respondent numbers 1 and 2. You also want to file an affidavit? No. No. He is present and submits that the respondent numbers 1 and 2 would not be filing their affidavit in opposition in the matter. Next para. Although notice on respondent number 4 is deemed to be duly served, but nonetheless, taking note of the address given for respondent number 4 in the cause title of this writ petition, as well as the cause title provided in page 40 of the writ petition, or the learned counsel for the petitioner shall apprise the court about the correct postal address of respondent number 4, and also whether the respondent number 4 still is in existence or not. List on when?
Anytime
After 3 weeks?
3 weeks, Your Lordship.
Give a date after 3 weeks.
So, Lordship, our name may be shown in the post.
Okay.
Standing Counsel AIDC, Lordship.
Okay. The registry shall reflect the name of SC, AIDC in the cause list. Listing the matter next. Just a moment. Your name will not be shown. You have not filed your Vakalatma, or you are a standing counsel or engaged lawyer?
Yes, Lordship. Mr. Zeke Goswami, he is standing counsel, Lordship, AIDC.
He is a standing counsel.
Yes, Lordship.
Okay. Is it, just strike out there and say the learned standing counsel for the respondent number 3 shall file his memo of appearance, whereupon the registry shall reflect their names in the cause list while listing the matter next. You have to file your memo of appearance. Otherwise, how will somebody know that you are there? In the record, it is not there. That's why I called it back, because I did not find it.
5th of June.
Obliged, Lordship.
Item 32.
Okay. Lordship, I'm praying for adjournment for today, Lordship.
Just a moment. Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. Matters is adjourned today. List after
Any days, Lordship.
a week.
33.
Just a moment. Let us see the order of the Supreme Court.
Yes,
Where is that?
First order is, Lordship will find at page 37 was the first order. Learned counsel appearing on behalf of the state of Assam is directed to seek instructions whether the petitioner can be adjusted. Thereafter, my lord, finally.
Just a moment. Page 38.
Yes, finally page 38, my lord. So and so senior counsel for the petitioner after arguing
No,
for some.
38 does not say that. No, 38
No,
says that.
37 says, my lord.
37. Okay.
Yes.
Just a moment.
My lord,
Just a moment. Yes, okay, 38.
yes, thereafter, my lord, 38 order was passed with a liberty to submit a representation before the respondents, my lord. And that representation was filed page 39, my lord.
Yes.
He basically prayed that if she can be adjusted in any post, because in the initial recruitment, there was a flaw that there was no women reservation. And that flaw was admitted by in the RTI case by the department.
that your lordship will find at page 35.
You see, we'll find it very difficult. You see, there is a recruitment process. In connection with that recruitment process, the decisions were taken, correct? And there was no provision for reservation of women. Now, once this exercise ends, the selection process terminates. Therefore, even if the government wants, there are authorities in the Supreme Court, various judgment which says that Article 14 and 16 has to be complied with. Your case cannot be directed as a pick and choose to consider your appointment. You have to be considered in your class. Because if the recruitment process is held, it has to be amongst your class. That you cannot be, we cannot do, although there's a observation of the Supreme Court that whether you can be adjusted somewhere. But that is something which we can't pass an order.
So far as the reservation is, women reservation is concerned, page 35 in the RTI case, it's an admitted factual position that in that particular selection process, they have committed a mistake, my lord. Because
it's okay, but you see, we'll have to then set aside. Because if let us say that 10 posts were advertised, let's just give you an example. 10 posts were advertised, you say that 33% was to be for women. Which includes again those parallel and horizontal reservations.
Yes.
Now, if that is wrong, you have to set aside the process or that part of the process where you can be fitted.
Actually, in that particular selection process was challenged in various petitions, various grounds, my lord. Ultimately, it was a court-monitored appointment. The entire appointment was made in a court-monitored manner. And petitioner also filed a petition, my lord, regarding her claims regarding not maintaining the reservation, women reservation. But unfortunately, my lord, her petition was dismissed on the grounds like, my lord, not awaiting the selected candidate party.
That was there, and then there was a delay.
There was a delay also, delay in challenging on those grounds, my lord. My lord, I cannot dispute all those things are based on record.
No,
I
we
build up
are not asking to revisit that. What we are saying is that, you see, if the process is incorrect, let us assume that you are right. The process was incorrect.
Yes, ma'am. I'm sorry.
Now, even if it is incorrect, the procedure was wrong. Now, please tell us, how will the court give you a relief?
Look, at this stage, what, my lord, my understanding is that, my lord, I cannot go back to that particular selection process, or I cannot make any claim from that selection process. Much water has flown as of today. You know, since there was an endeavor made by the Honorable Appellate Court in the page 37 order, because there was an Honorable Appellate Court said, if you can adjust her anywhere, because a wrong was done, because page 35 order RTI case, you have admitted that there was something wrong in that selection, because there should have been more women. You have taken less women. So in that view of the matter, Honorable Appellate Court in page 37 said, kindly explore whether she can be adjusted. And finally, in view of that, the SLP was withdrawn with a liberty so that that prayer can be agitated. And this representation was filed, but the respondents passed the impugn order. If your lordships kindly come to the impugn order, they again reiterated the same old thing. And in the last line of the impugn order, they say, page 44. Last line of the impugn order, they say, have not any, her claim is therefore disposed of without any consideration. That perhaps, my lord.
No, we can't repeat. That's why we are asking you only one question. What relief you can expect from the court?
I'm only praying for a relief that if there are 5 vacancies as on now, if taking into consideration the previous, my lord, wrong that was committed, if she can be considered.
That can't be passed. That's why we said, that is the first statement we made. You see, any selection process, there are umpteen numbers of judgments, which says that we may refer to Umadevi. It says that the employment process must be in a transparent manner,
By selection.
and Article 14 must be adhered to. Now, the facet of Article 14 is that not only you, but your entire class has to be considered. So if it's for women, not only one woman can be picked up and said that now we are appointing you to fill up that reservation quota. They will have to ask for employment from all such women who may choose to apply.
Milord, I am totally at the, Milord, what can I say, Milord? I'll at the disposal of the respondent.
You'll have to show us way.
Only thing, Milord, if as a special case they can consider, I know that I cannot seek.
No, that is a direction we can't issue. It is hit by Article 14.
I cannot seek a mandamus from your lordships that you appoint direction to appoint in a particular post. Since there are vacancies, if
No,
they can
vacancies, you
consider.
see, vacancies are
understand.
available all throughout. Let us say in the government, before the last elections, the chief minister said 1 lakh vacancies will be given.
But this,
The opposition leader in one of the states, they said that we'll give a 1 crore appointments. Let us say 1 crore vacancies are available. Now, can A come and say 1 crore vacancies are there, so let them consider my candidature.
But this
Out
consideration.
of 1 crore, let my post be considered, one case for me be considered.
But this consideration at space 44, perhaps that is not the proper consideration. They say that they have disposed of the entire thing without consideration.
Correct. If it can't be, you see, it's an example I always give. Maybe you are listening it for the 10 times, I don't know. You see, a boy in Rajasthan, you just search in your mobile, you'll find it. A boy in Rajasthan was terminally ill. He had a desire to become the commissioner of police for a day. And the chief minister considered to it. He was made a police commissioner for a day. That's a part of history which I am narrating.
My lord.
Years and all, I won't remember, but this has happened. Now, let us say for some reason, post-retirement, not now, post-retirement, I'm out of my mind. I say that my last desire is to walk to moon. Because many people have gone there, I could not go. I can't afford the spacecrafts. Therefore, I say, and I'm also not fortunate like Sunita Williams. So what I say is that please construct a road for me from here to moon. Because nursery rhyme says the cow jumped over the moon. You know that?
Yes.
So if the cow can jump over the moon, why a road can't be constructed? So that's my last wish. Now, is it a compliable consideration if I give a representation to the government? How will they consider this? They will say it is illogical. What is wrong? And the second thing, which is connected, you will find there is a problem in mathematics. It says that if you take a piece of paper and hold it umpteen numbers of times, at one point it may so happen that the length of that compilation would reach moon. There's you check in your what you call in your mobile, you'll find it. That if a piece of paper is folded and refolded and refolded for umpteen numbers of time, at one point it can reach moon. So I give that logic that, well, if a paper can be folded and can be reached moon, why not a road can be constructed? But those things are illogical. It can't happen. So therefore, it can't be considered. It will be violation of Article 14, not one decision. We may have sympathy, but we can't give you direction.
Hearing. Well, can this be taken up in any other day for admission hearing? I'll just try my luck.
Always heard,
Readings are complete, madam. They
Huh?
have had the reply also.
this is already heard, there's nothing more to be given.
I'll try my luck, but I just try to.
No, your luck
go
would be,
through-
no, your luck would be, if you challenge the order in Supreme Court, then maybe perhaps.
Plus, Supreme
It's-
Court
no,
tried,
not that.
move
But it
one
can-
foot ahead.
No, this 142 is there, so therefore they can proceed.
They
from
can
there.
proceed.
That
So that's
is-
why in that process, Supreme Court moved, Honorable Supreme Court. But finally that did not yield any. So,
No, we can always only express our sympathy, but sorry, we'll dismiss it.
but can it be taken up any date in the next week, Miller? I'll just
No,
try to-
once we take up the matter, there's no point after this. Can't be adjourned like that.
Because in para 2 of my representation, that wrong is absolutely, that
That's
was
okay.
wrong.
If you know,
in
if
the
there's a wrong,
se-
you select the selection process, but not.
I challenge
you
also,
can't- But you
but
can't
my-
have a reservation.
my entire thing started from page 37 order of the Honorable Apex
I have
Court,
noticed
wherein,
that. I've noticed that. That's why
Yes.
we put you only one question.
wherein Honorable Apex Court has asked the state, you kindly explore the possibility if she can be adjusted. This was observed only because of the fact that Honorable Court was convinced with regard to that page 35 thing, wherein they have admitted that yes, there should have been more women reservation, women candidates. It says, Milord, the Director of Employment Craftsman Training appears to have violated the requirement of the above mentioned act under which 82 female candidates should
Yeah,
have
you are
been
reading where?
selected. Page 35, my lord.
35.
So this I got subsequently, my lord, not at the time of the writ petition. The commission is of the view that the petitioner already has the required information that the Director Employment Craftsman Training appears to have violated the requirement of above mentioned act under which 82 female candidates should have been selected and subject to availability of adequate number of eligible candidates instead of 64 against 272 number of vacancies. If these 82 female candidates would have been there, then, my lord, I come at serial number 1 amongst the 13, my lord. That I have explained in page 39, para 2, in my representation.
Page?
Page 39, para 2 of my representation, my lord. This aspect did not receive consideration, my lord. That had the provisions of the said act been applied, there would have been 82 women candidates, but only 64 candidates were appointed, leaving a balance of 18 women candidates together. Altogether, 125 candidates out of 272 were in general category. 30% of the said 125 come to 38, but only 25 were appointed, leaving the deficit 13. I am the first among those 13 awaiting appointment. This did not receive consideration.
Heard. Mr. H.K. Das, the counsel for the petitioner. Also heard Mr. S.P. Das, learned standing counsel for the
Respond number 2 and 3, madam.
respondent numbers 2 and 3. And before that, you write, and Mr. A. Chakravarti, learned A. Chakravarti, learned government advocate appearing for respondent number 1. Yes, madam. and employment advertisement was issued on, sorry, two separate advertisements, right?
Yes,
Two separate advertisements dated 7/3/2007 and 18/5/2007 were issued by the Director of Employment and Craftsman Training, Government of Assam, for appointment to grade 3 and grade 4 posts respectively. Full stop. The case of the petitioner is that adequate provision was not made for applying the Assam women within bracket reservation of vacancies in services and posts bracket close Act, 2005. Full stop. It is projected that instead of providing for 30% reservation for women, lesser vacancies were earmarked for the women. Stop. Accordingly, it is submitted that the petitioner is the only woman who is agitating for her appointment, as others have not challenged the selection process. Full stop. It is submitted by the learned counsel for the petitioner that the petitioner, being aggrieved by by her non-selection, had approached this court by filing WPC 1999 of 2012. And this court, by order dated 9/12/2013, I dismissed the petition. Full stop. Thereafter, the matter was taken up in appeal filed by the petitioner, which was dismissed by, the order is not there, date.
Date of the order, I have given body of the petition 2/3/2015. It's
Dated
not
2/3/2015, passed by the division bench in WA 50 of 2014. First, the aggrieved petitioner approached this court in a review jurisdiction. So, however, the division bench of this court, by an order dated 8/9/2016, had dismissed review petition number 131 of 2016. Full stop. The aggrieved petitioner had approached the Supreme Court of India against the dismissal of WA 50 of 2014, and the Supreme Court of India, by an order dated 6/3/2020, passed in SLPC 9280-9281 of 2017, directed the government, the government advocate for the state of Assam to seek instructions whether the petitioner can be adjusted. Full stop. Next, it is submitted that the petitioner being hopeful of consideration by the state government, withdrew the said SLP with a view to make a representation before the state government. And according to the Supreme Court of India, by order dated 2/9/2021, granted leave to the petitioner to withdraw the SLP and to submit representation before the state government. So, however, no observation was made on the merit of the representation. Full stop. Next, accordingly, the petitioner submitted a representation before the Director of Employment and Craftsman Training, Assam on 30/9/2021. However, the said authority by an order dated 5/1/2023 rejected the said representation without any consideration. Full stop. Thereafter, the petitioner had submitted another representation dated 23/3/2023. And as no communication was made to the petitioner from the present retribution has been filed under Article 226 of the Constitution of India. By which the petitioner has prayed for prayed for quashing of the said order dated 5/1/2023 and for direction upon the respondent authorities to select and appoint the petitioner in the post of junior assistant with retrospective effect with notional pay fixation to grade junior assistant or any other grade 3 post. Next one. I'll complete the dictation in chambers because I have a meeting at 4:30. Fine. Other matters I will not be able to take up. Disposed of. I'll complete the dictation in chambers. Also. Other matters I will not be having time to take up.
One matter, next matter, item 35. Here the respondents have filed their affidavit. I am not willing to file any reply. Can be taken up any hearing day for it. This is a matter
We are not fixing a date, will be rolled over. There are plenty of matters I can't fix a date right now.
Lordship.
All will be rolled over.
Fine.
Take care of it.
Fine.
It will be rolled over. We are not fixing a date.
Fine, absolutely.